yellow building gate.
বলবে
হ্যাঁ বলিয়ে দিলাম।
তারপর বলেছো কি আছে সিনিয়র কে আছে मतलब I am praying leave to file an intra-court appeal on the basis of the my lord server copy
My lord will answer.
order passed on 10th July 2025 my lord 10th July and my lord
When did you apply?
my lord
When did you apply for the
my
certificate?
lord applied on 10th my lord and my lord server copy I my lord in the server on 13 my lord and today my lord I prepared and I am praying for leave.
Yes, leave granted.
May I permit your lordship? For inclusion, your lordship.
For
Inclusion.
appeal or application?
Appeal.
You have to wait for some time.
Lordship urgency.
You don't have a stay petition along with the appeal.
Newly filed match.
So do you have a stay petition with the appeal?
Yes, lordship. Kindly.
My lord, may I permit to mention for inclusion, my lord? Inclusion, my lord.
Appeal or application?
Yes, my lord.
Appeal or application?
Both.
Both.
Grateful, my lord.
My lord, I had
Wait.
let the learned
May I have your lordships kindly, my lord, to mention, my lord, on intra-court appeal, my lord, for inclusion in the list. My lord, there is some urgency in the matter, my lord. So what I am most humbly beseeching your lordship,
why is there an urgency?
my lord, the honorable single judge has passed an order, my lord, issued a direction for demolition of the subject structure. On the basis of a report, my lord, without granting us any opportunity to deal with.
You're not a party to the writ petition.
Predicament from 2 p.m. the primary matters are also fixed, my lord. Any time, my lord.
Demolition, why you are coming to us? The municipality.
No. This was filed under Group 9, my lord, wetland.
Monday it will be there.
Monday I will be here, my lord. But probably there will be a resolution, my lord.
We won't be there.
No.
There is let it appear on Monday.
Lord.
If it so happens, if you are in problem, you tell us.
Very.
If your other side does not come for any reason, we shall keep it on Tuesday.
That is what I was apprehending, my lord.
No, your demolition, you are apprehending.
No. On 21st, my lord, the other side may not appear. That is what I am.
Give a notice.
Very.
You give a notice today that it will appear on the 21st.
Your lordships will be taking it up on 21st.
Notice serve করেছে?
Yes.
Inform others.
My lord, may I have the leave to mention, my lord? Oh,
I did audience it. Applicant to the audience.
My lord, leave to mention a matter, my lord. I had mentioned 2 weeks ago. Your lordship had asked me to come back, my lord. My lord, I want the application and the appeal to be listed. It's an appeal from an order of 2022. 2022? I had mentioned 2 weeks ago, my lord. Your lordship had asked me to come back after 2 weeks. For some time. You've seen the list. My lord, it is included in the list, my lord. And then monthly list. August monthly list. Monthly list. August monthly list. Extremely obliged.
I have your leave, lordship's leave, my lord, to mention item 25, your lordship.
It was called on, Miss Banerjee.
No, my lord, it was.
Yes. We called the matter and we rose because there was nobody. The entire monthly list was called. And I told my lord that.
My lord, monthly subject.
Yes.
My lord, we were keeping our track, my lord. We don't. And also, my lord, this is not. I am the respondent in the appeal.
Whatever.
It is the state of West Bengal's appeal. So they are running away anyway. They will not
Should have
come.
come when the matter was called.
My lord,
Matter was called.
my lord, I am keeping a track, my lord. Even today, my lord, it says from item 17. My lord, I am the respondent. I am suffering, my lord, an injunction, my lord. That
Where you, madam? Matter, we are not making a misstatement. They are having a call of the combined list. If your juniors and your clerks do not keep notice of that, are we to be blamed for that?
no, of course not,
When
my
the
lord. But
matter
the
was
board
called-
was not showing, my lord. I don't.
Police line.
We remembered that matter. And we took note. You mentioned the matter. And the matter got called on. And I told my lord that, look, they are not here. We remember this.
My lord, after Monday, I mentioned
Yes,
this
yes,
Monday,
yes,
my lord, only.
yes, after that.
And with your lordship's permission, I have given notice.
Banerjee, if you keep challenging us,
No, I am not doing that at all. But all I am bringing to your lordship's notice, I am the respondent in the matter.
You do
The
one
carriage
thing,
of proceeding was with state of West Bengal. It is their appeal.
what we have seen. Our monthly list will be কবে হবে? Monthly list.
August.
Kindly see today's list also, my lord, it says.
Fourth will be the monthly list. Fourth will be the monthly list. If the matter is again called on, please make it convenient to appear. And if on fourth it will be getting a number in the list, you give a notice mention, we will consider your upgradation here. Yes, madam.
Grateful.
My lord, may I be permitted to mention one application for inclusion? Application and appeal.
All
Yes,
new
my lord.
applications, please file. New application file with notice. Are you mentioning
Yes,
about notice?
we are mentioning upon it.
Huh? Yes.
Malan, this is an original side matter, Malan.
Pardon?
Original side matter, Malan. May I mention? Malan, there is a grave urgency, Malan. Yesterday, my learned friend, Malan, Mr. Shastri had mentioned.
Whenever you come, there's a grave urgency.
Malan, that's why I get the Malan, opportunity. Orders are not supposed to, Malan, mention, Malan. Malan, what has happened, Malan? On
Same matter that he mentioned yesterday.
yes, Malan. Malan, I was seeking an Malan, urgent listing, Malan.
The original side list টা কবে আছে? মঙ্গলবার না? না, মাথা সাহেবের সাথে
ওই
পাঁচ
MRT
তারিখ আছে কিন্তু সোমবার আছে।
Malan, it's a small.
সোমবারের লিস্টে এটাকে দিয়ে দিন।
Malan, the only problem, Malan, again, Malan, we are again under a precarious situation that there might be the other side, Malan, may not.
This is the blacklisting.
Yes, Malan, 21st is the last date for putting in the Malan, the documents, Malan. And Malan, it's a pure case where I can understand, Malan, the respondents do not have the money. They paid the entire money, and after that, when we asked for the
Mr. Rai, when did you file? Yesterday?
yes, immediately 15th order,
Your other side.
Mr. Mukherjee, Mr. S.N. Mukherjee. I mean, along with Kichil. No, the applicant record. Arman Chaudhary is the applicant record.
21st of July.
I've given notice already, Malan. Malan, tomorrow, anytime if it's possible, Malan.
Tomorrow the problem is from 2 p.m. we have the primary matters.
I know, Malan.
It will be in the list. Hopefully it will be reached.
Tomorrow, Malan. But I'll again give notice to my learned friends, Malan.
Okay.
সাড়ে বারোটায় লিস্ট দিয়ে দাও। সাড়ে বারোটায় লিস্ট করে এটা দিয়ে
Sorry. Malan, I'm very grateful, Malan. I might make a prayer on that day for a limited interim order if the other side does not appear, Malan.
No,
You
need-
tell Mr. Mukherjee.
I have informed Mr. Mukherjee. I'll tell him again, Malan. But I've also told him yesterday evening, I've told him, Malan. I'm very grateful, dear Lordship. Very grateful.
Yes, all the list.
Lordship, as
This is
About you.
an original side writ appeal.
We allowed your prayer.
This is a
So
second.
you wait, enjoy that allowance and come later.
Lordship, may I be permitted to mention an original side matter, Lordship? This is a Group 9 appeal, Lordship, originating from a writ, my lord, that was,
Which year appeal?
Lordship, 2022.
22. Sir, wait for some time.
Lordship,
Let the combined list be published. Then remind us.
Lordship, I bow down. I am mentioning this matter as in person, Lordship. The matter MAT 997 was mentioned before your Lordship, but it was to be listed on 10th as per my given date on the presentation form. Learned single judge is about to hear the matter on tomorrow, Lordship. 18th is date fixed before the learned single judge, Lordship.
Your Lordship, I am in person in this matter, Your Lordship, and I am under a serious threat of life and liberty. This person who is mentioning this matter, I am the writ petitioner before Honorable Justice Amrita Sinha. My family's life and liberty in a great stake because they are filing frivolous false complaints against my son, my husband. This may be heard, Your Lordship, because Honorable Justice Amrita Sinha has been pleased to request for deciding this matter, Your Lordship.
Will be there tomorrow.
Grateful,
Deeply
Lordship.
obliged, deeply obliged, Your Lordship.
Tomorrow you
Yes. It's an original side writ appeal. I was a successful writ petitioner where my complaint was quashed. A police complaint lodged by the bank was quashed. The bank has preferred a writ appeal. They were enjoying an interim order. The interim order elapsed.
appeal of which year?
Appeal of 2025,
2020,
2024.
2024, it is their appeal.
It is
Have
their
they
appeal.
got any interim order?
They have got an interim order. That interim order period has expired.
So
I
very
am,
good.
Lordship,
Enjoy.
that the difficulty is because the complaint, there was an interim order. Now the authorities have come into action, and that is the reason which is affecting me. Because this
What
was
action? There is no interim order. What
Lordship, the writ
you are
petition.
not the appellant.
The writ petition was filed, quashing a complaint lodged with CBI. Thereafter, I won the writ petition. The bank filed the appeal.
Remind us next week. Let us see.
Grateful.
Give a notice.
Submit
and
to
remind
mention
us.
for inclusion, my lord. Group
Application.
application.
No, appeal.
No application, my lord.
Make up your mind.
Group 9 application, my lord.
Okay. Fresh.
Please.
Your Lordship, for inclusion, this is for hearing after paper book is published. Paper books have
Sir,
been
remind us after the combined list comes out. Fourth, it will be coming out. Mention on Thursday. We shall place it. We shall consider it.
next Thursday.
Give a notice and number.
Much.
হ্যাঁ বলুন।
নাম স্যার আমি ইনক্লুশন হতে চাই
হ্যাঁ হ্যাঁ
ইনক্লুশন হতে চাই স্যার পার্টি পার্টি
আপনার উকিল বাবু আছে?
আমার উকিল বাবু স্যার অ্যাকচুয়ালি এটা অনেকদিন ধরে কেসটা অন্য আমার বাড়িটা নিয়ে স্টেট ব্যাংক এখানে দুর্নীতি করেছে। আমি স্যার আগের সপ্তাহে আপনি একটা দুর্নীতি দিয়ে ভালো পেপারে দিয়েছিল আপনার নিয়ে যে দুর্নীতি হস্তক্ষেপ করলে আপনি যে কোনো কাজে দুর্নীতি করবেন। তো আমার সাথে ব্যাংক একটা বড় রকমের
খবরের কাগজ দেখে চলে এসছে।
না স্যার খবর কাগজ তো মানুষ তো জানবে ওই কারণে স্যার যে আপনি একটা ভালো রায় দিচ্ছেন।
আপনার একটা পদ্ধতি আছে। আপনার যে উকিল বাবু আছেন।
আমার উকিল বাবু স্যার অ্যাকচুয়ালি যিনি ছিলেন আগের 6 মাস আগে উনি এটা স্যার চিফ জাস্টিসের কাছে গেছিলেন, ব্যাংক এখানে কি করলো সার্ভিস আইনে ঢুকে দিয়েছে।
আবার অন্য কথা, আপনাকে শুধু জিজ্ঞেস করছি আপনার উকিল বাবু আছেন কি?
আমার এই মুহূর্তে স্যার নেই।
কে ছিলেন আপনার?
আগে ছিল তুলসী দাস রায়।
তুলসী দাস?
হ্যাঁ স্যার।
ওনার ওকালতনামা কি আপনি ক্যান্সেল করে দিয়েছেন?
না স্যার।
তাহলে আপনাকে তো উকিল বাবুকে নিয়ে আসতে হবে।
আচ্ছা স্যার।
আপনি নোটিশ দিন।
আচ্ছা।
উকিল বাবুকে রিকোয়েস্ট করুন।
আচ্ছা।
উনি এসে বললে আমরা কনসিডার। একটা পদ্ধতি আছে।
না ঠিক আছে স্যার, আমি এটা দেখবেন স্যার ব্যাংকের দুর্নীতি ধরে এটা বড় রকমের স্ক্যান্ডাল, বড় রকমের স্ক্যান্ডাল, কোটি কোটি টাকা।
আপনি সামনের বৃহস্পতিবার উকিল বাবুকে নিয়ে আসুন নোটিশ দিয়ে, তারপর
প্রণাম স্যার।
ইয়েস কল।
Lord, I am for the CSC.
I am for the appeal. My lord, kindly see the last order.
The Lordship takes up the order under challenge for once. The petitioner was accused of theft of electricity.
My lord, kindly see the order, third paragraph, that is the last.
Third paragraph of the order impute.
The petitioner, however, has expressed his willingness to deposit the provisional assess amount, but prayer has been made for granting suitable installment. There was no such prayer. Our prayer was to restore the connection, and that is the objection, my lord.
So restoration of connection, you have got a favorable order, sir.
No.
Restoration, you have to deposit the entire assessed amount.
My lord, that is.
You are an expert in electricity, you know that, don't know that?
I know that. That is not the question. Question is that.
What is the question? Tell us.
Question is that we have not tried to get an order for installment. We prayed
Casting aspersion on the court.
Then Mr. Dhaldar, you should approach the single judge.
My lord, I will.
I have not.
I will go there. But what is my prayer?
We will record that we are disposing of this appeal with liberty to you to approach the learned single.
My lord, in the meantime, what I am saying, one more.
Basically casting aspersion on the court.
No.
That court is recording false submissions.
Single judge.
What? That liberty.
And he has pursuant to that order, he has paid 50%.
We paid.
Current was restored. Thereafter, my lord, this appeal was filed. And my lord, he has made default in payment.
payment of installment.
Yes, he has paid 50% in terms of the order passed.
So he deposited 50%.
Absolutely, in terms of this order. This is,
In order to
basically-
get restoration, we paid 50%, line has been restored. Then my lord, remaining amount is so poor, he could not pay the amount. And 11th of this month, they have disconnected the line.
because of the non-payment in terms of the order passed by
What
the
I am
single
saying,
judge.
I go to the honorable single bench. In the meantime, within a week, in the meantime, the electric line be restored, my lord. That is my only prayer.
Indeed.
I'll go to the honorable single bench as per my lord direction.
Without making any payments.
Payment. We paid
In terms of the order,
What do you want? What
he wants restoration.
No, we want to pay the amount as per direction. We paid it 50%. Remaining amount, there is a installment passed by the honorable single bench, but we never tried to appeal before the honorable single bench for installment of the payment. We are not assured that we paid for the restoration.
Why have you come to us?
Because of this.
Because of this, you have to go and tell this.
Well, we'll go.
So you withdraw the appeal and go. What is the
Absolutely.
problem?
And Milord, let this be recorded. Acha,
Are you
withdraw নিচ্ছে।
withdrawing the appeal, sir? On the prayer of Mr. Haldar, learned it appearing for the appellant.
Has come.
Yes, Mr.
But kindly turn to page 53. This is the tender notice.
Five
53.
3.
That this is the tender for providing cleaning and housekeeping services for 3 years. Now kindly turn to the relevant portion which I am really feeling aggrieved of. Turn to page 65. There's a clause 26.4. The situation which was contemplated, if there is a tie, what would happen? In case of tie, tenderer would be selected by lots. Now this was subsequently changed. Page 52. Kindly turn to the change portion at page 142. It's another 130.
না স্যার আগে করিজেন্ডামটা 53 তে হলো
No, this term was corrected, Mr.
Yes.
হ্যাঁ
52.
page 52 is the corrigendum.
That was corrected, and the corrected form, how it is to be done, that will also kindly find out at page 130.
130.
No, not a meeting. Sorry, but this is the meeting. I will come to it later. 142. The relevant portion of the 142.
Yes.
Situation 3, in case of tie bid. This was relevant at the point of consideration. It says, in addition to what has been stated in situation 1 and 2 above, the following procedure should be adopted when there is a tie among L1 bidders. This is the case not L1 bidders or tie. Keeping the discovered L1 rate as ceiling, sealed bids may be invited from all the L1 bidders, and out of those, the lowest one may be selected. It was not done. If none of the L1 bidders ready to offer further reduced rates, then what will happen? For items divisible in nature, the work may be distributed equally among the consenting L1 bidders. But instead of doing this, they have not preferred one. They have taken the and kindly come to the reason which they have spelled out in their minutes is absolutely an extraneous reason. That is at page 130. Have you got it 130? Yes. The meeting started with the active participation of the members of the tender committee and the representative from the L1 bidders who were present. The representatives for all qualified L1 bidders except from Dynamic Services Security Limited were present in the meeting. One, as per situation 3 of the memorandum, dated 7 June 2022, due laid down procedure were adopted. As discovered, L1 rate was already the lowest. The norm of further invitation of sealed bids from all the L1 bidders was found to be not applicable in the current meeting. Resorting to the next procedure, the situation 3, the proposal of equal distribution of the working among the consenting L1 bidders was discussed with L1 bidders. This was the procedure. Why not I was rejected? In the meanwhile, the tender committee meeting was impacted by representation made by student representatives and staff representatives with their major demand being allocating the work to one single company. But how could the laid down guideline be violated on the strength of some representations by student and the other persons? And thereby, the statutory authorities are guided by the extraneous considerations. Their non-means, it should be equally distributed to the L1 bidders. And that you depart because there is some representation. How could the students and the other staff principals come to know?
Next clause, Mr.
Yes.
Seven of the
Seven of the L1 bidders were in favor of equal distribution among them initially. One of the L1 bidders against the same, and another L1 bidder did not express his opinion. It is not a factor at all because your guideline is you have to distribute equally. It doesn't depend on the desire of the bidders. Among the consenting L1 bidders. But this is the whole issue. The learned judge rejected my prayer saying that you have come late. That I would come to court when the offer is made. I approached the court immediately when this L1 bidder was selected. 94.
Have you added that person as a party?
Yes,
Who was
appearing?
Yes.
What did the single judge?
When a single judge will say at page 165 that the work was awarded to him and you approach the court thereafter. But
Sir, 136.
Obviously, I have to approach the court after the work order is given. At page 136 is the order of the learned single judge. Paragraph 7 of the order says, the tender committee also took note of the fact that there was a representation made by the student representatives and the staff representatives with a request to allot work to one single company instead of multiple companies. Now, this consideration in Muhammad submission is beyond the law.
Mr. Odaji, kindly come to page 116.
116, yes.
Same. That is same as you showed us in 140.
Yes, we'll
Kindly
see.
come to paragraph 2 of that.
However, prior to such acceptance of temper, accepting authority shall examine.
Now, clause D.
Whether EMD was issued online through tender.
No, whether the tender inviting authority has provided sufficient justification for acceptance.
Yes.
So that justification is the representation.
But can that be taken into consideration? Well, the authority have to decide on the basis of the guideline. They cannot take outside that representation.
No, guideline provides that if there is
Is that
sufficient justification, whether the has provided sufficient for acceptance of the selected bid and certified that the quoted rate is reasonable.
Because that justification must be within the parameters of the tender condition. But the students and others would come and say, no, give it to one. And that justification would be that they have represented, therefore I'm giving to one. Then what's the value of this? These are all administrative decision must be taken on the strength of their own independent judgment of the administrative guidelines. But can the extraneous consideration, what is the role of the students and others in this contract?
Guidelines keeping the discovered rate as ceiling. Sealed bids may be invited from L1 out of those doors.
Because justification could have been that the past record of this particular is not well or something else that is within the parameters of tender.
কলেজ যেটা হসপিটাল সেখানে কিন্তু না এটা হচ্ছে ফর ডিভিজিবল ইন নেচার একটা হচ্ছে হসপিটাল তার আগে তো এটা ডিভিজিবল হচ্ছে না তো তাহলে এইটা আগে কেন করবে এটা তো সেকেন্ড প্যারাগ্রাফ কিপিং দ্য ডিসকভার্ড L1 যদি 8 জন থাকে তাহলে 8 জনের মধ্যে লোয়েস্ট রেটটাকে সিলিং রেখে আবার বলবে বিট কর সেটা করলো না রাইট এখানে টাই হয়েছে 8 জনের মধ্যে
আফটার দি টাই সেটা এখানে বলছে একজন
না সেটা তো ইকুয়াল ডিস্ট্রিবিউশন দ্যাট ইজ ফর 4 130 প্যারাগ্রাফ 4 but that is for equal distribution এখানে তো equal distribution হয় দরকার নেই এখানে বলছে বেশ আবার এই হবে সেকেন্ড প্যারাটা দেখো keeping the discovered L1 data ceiling bid sealed bids is invited from all L1 bidders out of those the lowest one may be selected এটা করলে এটা তো একটা প্রসেস দিয়ে দিয়েছে এটাতেও যদি না হয় তখন ABCD আছে বাট এইটা তো আগে করা উচিত ছিল Correct. It's equal distribution. Equal distribution হচ্ছে A. তার আগে তো এই
I beg to represent the tender inviting authority, the state lordship.
I am for added respondent date.
Mr. Galib, kindly come to page 116. Or page 142, whichever is convenient for you. The situation 3 envisages a situation where there are multiple L1 bidders and there's a tie. See the second paragraph. That's the first thing which the tendering authority ought to have done. Keeping the discovered L1 rate as ceiling, sealed bids may be invited from all the L1 bidders, and out of those, the lowest one may be selected. The tendering authority didn't do this. No,
That is one.
Am I correct in my understanding?
So, my lord, the authority should have taken recourse to that first, lordships.
That's what I'm asking you.
It was not taken because reasons, my lord, have been given, my lord. Deliberations, we have taken recourse to situation 3, capital clause A, 1C. Why, my lord?
But why?
Reasons are, my lord, given in the minutes. My lord, may I, my lord, in respectful reply to my learned senior friend, my lord, representing, my lord.
Which clause you are in? 3A.
We have taken recourse to, my lord. No. Wow. 116, my lord. That is the tiebreaker memo. That is also at page 140 also.
Yes.
That is at 140 also. So we have taken recourse to, my lord, situation 3, that is clause A, subclause C, we have taken recourse to.
Understood.
Why,
Right.
my lord? Now, first respectful reply, my lord, to my learned senior friend is that delay was not only the ground on which, my lord, the writ petition was dismissed. Delay was not only the ground.
First, you answer our question.
Lordship. My lord, may I respectfully invite your lordships? My lord, why? Page, my lord, 130. 130 to 135 is our defense. My lord, on 24th March 2025 was the meeting held by the tender committee. Kindly seize the minutes, lordship. The meeting started with active participation of the members of the tender committee and representatives from the L1 bidders who were present. The representatives from all qualified L1 bidders, except from Dynamic Service and Security Limited, were present in the meeting. The point was discussion resolution. As per situation 3 of the memorandum dated due laid down procedure were adopted. As the discovered L1 rate was already the lowest, the norm of further invitation of sealed bids from all the L1 bidders was found to be not applicable in the current scenario.
Why? That's exactly what we're asking.
As because it is already the lowest.
No, but you see the clause, 116, you see the clause. It says you keep the lowest ones, you keep as the ceiling rate and you invite again. And
Keeping
whoever's
the discovered L1 rate as ceiling,
right,
sealed bids may be invited from all the L1 bidders,
right,
and out of those, the lowest one may be selected.
all the L1 bidders.
Lordship.
So it envisage a situation where there are multiple L1 bidders. And your clause 1 at page 130 glosses over that completely.
No, my lord, lordship, the tender inviting authority has the liberty to do this.
Where?
I will support, my lord. I will support it by the judgment, lordship. I am supported by
judgment.
We can do it, lordship. My lord, since the tender is for housekeeping of a hospital, my lord, tender inviting authority has the liberty to go
get the best deal.
No, not always.
Always to get the best deal.
Not all. Yes, best deal.
So,
but on the basis of my lord.
But bypassing the guidelines laid down.
Because they have taken recourse to this memorandum of tiebreaker, but not that, but some other. It is within the parameter of the memo in question. But kindly see the reason, my lord, and it is, my lord. Kindly see the reason they have given, lordship. Now, my lord, they are resorting to the next procedure, as mentioned in point A1 of situation 3, the proposal of equal distribution of work amongst the consenting L1 bidders.
Where are you?
Page 130.
Page 130.
Well, I am reading page 130 to 134 is our defense, lordship.
All right, please. What you
So, I am reading at page 130, lordship. Resorting to the next procedure, as mentioned in point A1 of situation 3, that is, my lord, A1 is the work may be distributed equally among the consenting L1 bidders. This is the next. Resorting the next procedures, as mentioned in A1 of the proposal of equal distribution of work among the consenting L1 bidders was discussed with the L1 bidders present in the meeting. In the meanwhile, the tender committee meeting was impacted by representation made by student representatives and staff representatives, with a major demand being allocating the work to one single company instead of multiple companies in their best interest. They brought forward that issue of one of the previous agencies, Skyland Security Organization, who had previously defaulted in payment of salaries, ESI and EPF benefits, and his termination for having been absconded all on a sudden. Now, 7 of the L1 bidders were in favor of equal distribution among them initially. One of the L1 bidder was against the same, and another L1 bidder did not express his opinion either in favor or against the same. This was the situation. As discussed and proposed by the committee, keeping in view all the operational and administrative issues in the best interest of all public services, allocating the work to the 8 L1 bidders will hamper general operations, patient care, and student affairs. The previous case of Skyland Security Organization bears testament to the fact. Some of the bidders also partially agreed prima facie to the above operational issues in principle, however, in their professional interest, highlighted the request for equal distribution. Miller, may I read out 131. Thus, it was made clear to all the L1 bidders present that the committee proposes to draw reference to Rule A 2C, where it has been stated that the number of personnel supplied in a single contract during the last 2 years shall be considered for allocation of the work. Similarly, we have taken recourse to A2C. The committee members therefore decided to thoroughly delve upon the submitted credentials of all the L1 bidders in accordance with the above criteria. As per the analysis of credentials submitted by the bidders and in reference to point number 6 above, the statistics of all the bidders were discussed in the meeting and confirmation regarding the same was also provided by all the L1 bidders. So they were confirmed by all the bidders. A further time of 48 hours was given to the above bidders to clarify the above statistics with reference to the bids submitted by them in the portal and convey the same through email along with other submission if any. So again we meet. Again, the tender committee meets, my lord, after 48 hours. What is that, my lord? At page, my lord, 132. They meet on 26 March 2025. Kindly seize, my lord, the minutes. The point was discussions and resolution of the current meeting. After lapse of 48 hours, it was found that there has been no submission regarding any difference in statistics of manpower as were discussed during the previous meeting. The previous decision of the committee, keeping the view in the operational and administrative issues in the best interest of public service, allocating the work to 8 L1 bidders will hamper general operation, patient care, and student affairs was reinforced. Thus, the committee upheld the reference to Rule A2C, where it has been stated that the number of personnel supplied in a single contract during the last 2 years shall be considered for allocation of the work. After careful and diligent reanalysis of all the credentials submitted by the L1 bidders and further deliberations on all the aspects, CFS emerged at the agency in compliance to the above norms. Therefore, the committee resolved unanimously to provide work order and execute the contract with CFS Management Private Limited for a period of 3 years. Now, my lord, page 133, last page I want to place, my lord. Before, my lord, I go on to the next level of my respectful submission. Now, what we have did at page 133.
That is your explanation. What is my brother's query? Please answer. Why?
My lord, operational.
Yeah, just a moment. Operational and administrative reasons, all right. But situation 3, you have avoided this situation 3 by taking recourse to
A2.
Situation 3, A Roman
2C.
A Roman 2 by taking recourse to A Roman 2.
A Roman not 2, my lord.
A2C.
A
C.
Clause C.
A2C.
Lordship. 8-2C. A2C.
Correct.
Lordship. Reason, my lord, which is reflected in the minutes. Because there was a very, my lord, very bad experience, and it's a matter, the nature of work in tender relates to housekeeping. And, my lord, there was, my lord, problem with the single tender on the last occasion when it was distributed. This was the reason. And it is, my lord, it is a discernible reason, my lord, in my humble understanding, which has been given, my lord, sanctioned by the Honorable Supreme Court. The tender inventing authority can do this.
Fresh bids will be invited from all
Manpower rate of the
right. Only amongst correct. We won it. But it
Lordship.
Yes.
So, my lord, having taken recourse to this A, clause 2, subclause C, my lord, with regard to the manpower of for the single year of this bidders, my lord, we found, my lord, this evaluation was done on the basis of all the documents we uploaded by the bidders at the time of submitting the bid. So, having gone through and evaluating all these papers which were submitted by them at the time of bidding, my lord, we found that CFAs, my lord, may I respectfully hand over, that he was having the highest manpower, the person who has been awarded.
Why should we do that? Where is that manpower issue where you have stated 132?
My lord, CFAs is 529. Last. The paper I have handed over just now.
What is this? Manpower.
Manpower. After evaluation.
Yes, contract was with him. With the petitioner? With the
No. Lordship, since the criterion chosen was supply of manpower, number of personnel supplied in a single contract during the last 3 years shall be considered. No.
So what you are showing this?
That there was compliance of A to C. In terms of manpower, this selectee, he was the highest, that is shown 529, and this petitioner was 235, and there were others also who were below him. That's why he was awarded the contract. Now, my lord, this fair play, lordship, this is, my lord, permissible, my lord. It's a tender, my lord, issue, my lord. My lord, may I place two judgments, my lord? This is permissible. Because discernible reason, and my lord, kindly sees, my lord, there are propositions on this. May I respectfully, my lord, submit, my lord, cite two judgments, my lord, Amageta. Amar Sir, आपने एक copy नहीं. Lordship, may I place this, my lord? My lord, proposition is, if there is any procedural aberration or my lord, discernible reason, taken by the tender inviting authority, my lord, there is no, my lord, scope of, my lord, judicial review of a tender matter. May I respectfully invite your lordships, my lord, to, my lord, paragraph 16, lordship. This is the 2025 ACC online AC 933. Judgment of April 25, 2025. My lord, para 16, my lord. The question of scope of judicial review in the case of award of contract has already been dealt with by the Honorable Supreme Court in the case of Jagdish Mondal, where the court observed as under. Para 16, 1-6.
I try to satisfy your lordship on that point. If we refer to the document, the memorandum dated 7/6/2022, where the situations are discussed in case of a tie bid.
Yes.
Here it reads that keeping the discovered L1 rate as this is 94 in my page 130, your lordship.
Which clause you have received?
No, situation in case of tie bid, situation 3. Now, keeping the discovered L1 rate as ceiling, sealed bids may be invited from all the L1 bidders, and out of those, the lowest may be selected. Now, in the minutes of the meeting, this is page 130, I think. Here, point number 1 discussed is, as per the situation 3 of the memorandum dated this, due laid down procedures were adopted. And now here, as the discovered L1 rate was already the lowest. The norm of further invitation of seal bids from L1 bidders was found not to be applicable. So, because they were participating in the minutes of the meeting, all of the
Just hypothetically, the L1 rate is 10 rupees.
yes,
So there are 10 persons give 10 rupees.
yes,
Bid was 10.
yes.
So guideline says that in such a situation, you have to go for a rebidding
Keeping
to
10 as the
ask whether any person amongst you will be giving 9 rupees or not.
But my submission is that they did not acquiesce to the idea that it cannot go lower. That is what the point 1 of the minutes of the meeting is trying to represent. That this was invited and people refused to go lower, which is why we are moving on to the situation in case of a tie bid, which is further down the memorandum in the 7622 document. Because the first point was not agreed upon by everyone, and
Where do you find that? Not agreed upon.
no, because this was already the lowest and it was recorded. And if there was an objection, this would not have been recorded. That is the hypothesis I am.
This meeting they were present.
Your Lordship, in the minutes of meeting.
Committee meeting with the authorized representatives of the qualified L1 bidders. They were present.
Your Lordship, they were all throughout participating in the process of the tender. Nothing was done behind their backs. I mean, even I had access to the same amount of information they had. Nonetheless, also, may I try to simplify the matter, since this is a question of manpower. Your Lordship, since this is a question of manpower, we have, my learned senior has also referred to the case where 2AC says in supply of manpower, this situation may be resorted to. And
Where you are reading?
Your Lordship, the 2AC2, this is page 142. In case of supply of manpower.
Which clause?
2A, 3, sorry, I'm very sorry, 3A, 2C.
3A, 2C. 3A, 2C.
We are moving on the hypothesis that none of the L1 bidders are ready to accept lower rates. And that is why, since this is a contract of hospital staffing, it's a question of manpower, this was specifically applied.
See, in case of supply of manpower, see. Number of personnel is so much. Shall be considered.
So you have been given for 1 year.
My apologies.
Been given work order for 1 year.
No, 3 years. 3 years renewable at the end of every financial year. Page 134, kindly see, page 134 of the step.
See, it says 1 year renewable after every year for a maximum of 3 years.
And Your Lordship, if
it will be renewable.
Renewable.
It is
renewable.
And Your Lordship, if I may invite your kind attention to page 127.
Yes.
So the reasoning given was the petitioner was rejected on the grounds of insufficient manpower. The petitioner here is number 4, listed as number 4. And I am number 5. The reasoning is there, and Justice Sinha has also noted that. If I may place.
What is this status? Rejected AOC? What is the?
Your Lordship, in a single contract within last 3 years?
The column which says status. What is the status? The column which says status. At page 127.
Yes.
There's a column which says status.
Yes.
What is that?
So they were found insufficient in the consideration.
It says rejected AOC. What is that?
I am unable to answer.
Say that.
No, I am unable to answer that. But Your Lordship, in Justice Sinha's judgment, which was, we were not impleaded as a party in that writ. May I read the part? May I place the judgment by Justice Sinha?
No, we have gone through it.
Regarding the injunction, I had a submission to make.
Yes,
The,
yes.
the 41HA of the Specific Relief Act, Your Lordship, prohibits, whether it relates to public infrastructure works, it prohibits the asking of an injunction of the order. That is all.
41H.
HA is inserted in 2018.
Because
On the issue of infrastructure, there cannot be
for
any injunction.
specific performance.
Yes, but Schedule 5C talks about government colleges.
That's next to infrastructure, basic infrastructure.
Yes, but this is a basic infrastructure.
Anyway.
I think he's saying this is an infrastructure code. That's his case.
Number two, simple thing is Lordship kindly comes
Lord,
to
may I, Lordship, with regard to the scope of judicial review, with regard to tender authority, it's very. No, arekta achi,
Then give it.
Because the tender, the tendering authority
Which
has.
judgment you are relying, tell us now.
Has
Which more judgment?
NG projects, the interpretations with regard to the memorandum notification, tender on inviting authority has the liberty, has a leeway to go for any interpretation. And if two interpretations are plausible, the one taken up by the tendering authority has to be taken up, because scope of judicial review is very limited, NG projects, may I place this judgment also, Lordship. May I just, place the relevant paras, Lordship. The one I have already placed, NG project is reference is
Mr. Galib, give a copy. Give a copy to Mr. Bhattacharya.
2022 6 SCC 127. It's a reported judgment, very celebrated judgment.
Bad practice.
2022 6 SCC 127.
Paragraph?
Paras, my lord.
This was under Specific Relief Act.
No, Lordship, not specific relief. Overall views taken with regard to scope of judicial review in a tender matter. Even note of caution was also given to the Honorable High Court, by the Supreme Court.
Road construction.
May I rely upon para 10, Placita, G and H. May I just. Placita G and H, my lord, kindly cease, my lord. It was relying upon Tata Cellular. It cannot be denied that principle of judicial review would apply to the exercise of contractual powers by government bodies in order to prevent arbitrariness of favoritism. However, it must be clearly stated that there are inherent limitations in exercise of that power of judicial review. Government is a guardian of the finance of the state. It is expected to protect the financial interest of the state. The right to refuse the lowest or any other tender is always available to the government, but the principle laid down in 14 have to be kept in mind while accepting or refusing tender. There cannot be any question, Lord, kindly comes page of infringement of Article 14 if the government tries to get the best person or the best quotation. The right to choose cannot be considered to be an arbitrary power. Of course, if the said power is exercised for any collateral purpose, the exercise of that power will be struck down. Very good, Lordship. Kindly seize, my lord. My lord, page 135, placitum G. Same page, my lord. The principles deducible from the above are the modern trends to judicial restraint in administrative action. The court does not sit as a court of appeal, but merely reviews the manner in which the decision was made. The court does not have the expertise to correct the administrative decision. If a review of the administrative decision is permitted, it will be substituting its own views without the necessary expertise which itself may be fallible. Next, my lord. Page 136, my lord, kindly see Placita ABC. The terms of the invitation to tender cannot be open to judicial scrutiny because the invitation to tender is in the name of contract. Normally speaking, the decision to accept the tender or award the contract is reached by process of negotiations through several tiers. More often than not, such decisions are made qualitatively by experts. Here deliberation was made. The government must have freedom of contract. In other words, a fair play in the joints is a necessary concomitant for an administrative body functioning in an administrative sphere or quasi-judicial sphere. However, the decision must not only be tested by the application of necessary principles of reasonableness, including its other facts pointed out above, but must be free from arbitrariness, not affected by bias or actuated by malafide. Quashing decisions may impose heavy administrative burden on the administration and lead to increased and unbudgeted expenditure. Now, Millard, para 12 and 13. Paras 12 and 13. In Afcons Infrastructure Limited versus Nagpur Railway Corporation, this court held that the owner or the employer of a project having authored the tender document is the best person to understand and appreciate its requirements and interpret its documents. It was held as under, in other words, a mere disagreement with the decision-making process or the decision of the administrative authority is no reason for a constitutional court to interfere. The threshold of malafides.
All right, all right. Yes, Mr. Bhattacharya.
Kindly turn to page 130 once again. Well, I will show why this CFS was preferred. 130 clause 4. Seven of the L1 bidders were in favor of equal distribution among them initially. One of the L1 bidder was against the same. That one is CFS who has got the contract. Therefore, like against the interest of all the bidders, following the guideline, Millard, they have gone in favor of one because he had not agreed to the equal distribution. And then, Millard, the other thing which my learned friend Millard says that they are relied upon the supply of manpower, well, that will be incorporation of new clause in tender. The tender notice did not say that you have to have this minimum manpower supply. We all were found to be L1. First of all, you did not call for further bid, and then you disagree with 6 others, except one, for the reasons which is not very sound. This is the factual aspect. I don't want to trouble my lord with that. The decision sided by Mr. Khalif, in fact, supports my cause. 2025 SSC Online Supreme Court 933. The factual matrix was the tender was cancelled initially, and then it was made open for equal participation. That was challenged. Now the court says this is for better giving opportunity. Kindly come to the concluding paragraph, paragraph 23 of the said judgment. We will state that the decision of the authority is giving a fresh opportunity to all interested bidders to compete with each other in the process of the fresh selection. In our opinion, decision taken by the authority is not affecting the public interest. The first tender was cancelled. Paragraph 3, the factual matrix. A fresh tender was invited, someone challenged. To that, the Honorable Supreme Court says, if it is done afresh, giving opportunity to all, how are you affected? This is the Millard judgment, and Millard, the latest, and the other one which my learned friend submitted, Millard, is completely a different factual perspective. We are not challenging the condition of tender. That judgment was based on that you cannot challenge the condition of tender. Millard, we are here before the Honorable Court to ensure the conditions of tender and to make it viable. It cannot be, Millard, decided on extraneous consideration like students and others' representation. They had no business. But this is the simple thing. And it has been awarded for 1 year, subject to renewal. Millard, the Honorable Court can very well intervene if the court is satisfied that this was not done properly.
Millard, para 16 of the 2025 judgment. Para 16 of the 2025 judgment says,
Hardy, Mr.
Lord, may I take leave?
The present appeal has been preferred.
I am for the state.
For the applicant. This is my ability of service.
Yes.
Not improved order, you Lord, kindly see me, Lord. That page, my Lord, 82 of the application.
82.
82 of the application.
স্টুডিও সরিয়েছে এবার তুমি বলো তুমি
The petitioner alleged that the private respondent are carrying on an illegal bakery business by encroaching upon the property of the petitioner. Ordinary millet single judge hold that millet as there is a civil suit is there, millet in action of the police authorities will not be entertained, millet. And millet, my respectful submission is millet petitioner is owner of the land, millet, and millet file and civil suit, millet. In the suit, millet, injunction was passed, millet.
Injunction was passed.
Status quo was passed, and millet.
Status quo.
And thereafter, one application under.
When was the status quo order passed?
It was passed, my lord.
Where have you stated in your writ petition? Page 34, 39A.
35, lords. 35, my lord.
You also went for 144. 135. 35.
35 information slip, my lord. Information slip with regard to the injunction.
Information slip.
Page 35.
35 of lordship.
Before starting means we have started already. Please wait for your turn.
Without any annexer, that is my.
You are for the private
respondent. Without any, not a single annexer has been served, even the impugned order. That is another part, but in this.
All right, then we will not dismiss his appeal. We will adjourn it for you to take the copy and come.
That is, I am just informing you before the court, my lord.
The key code. Copy দিয়ে দিন। In course of hearing, the learned advocate appearing for the private respondent number 6
For my lord, I am for the appellant.
এই রে, ভয় লেগে যায় দেখলে।
I am for the rest.
Mr. Chattopadhyay, that preventive detention matter, what is the name of that?
Jahanara Bibi,
জাহানারা। এই ওকে কার্তিককে বলো এটা জাহানারা।
22nd 2 p.m.
22nd we have fixed another same matter. হবে তোমার।
Same matter?
হ্যাঁ।
পরে তাহলে ঘুরে আসবো না?
না না অন্য ম্যাটার কথা।
You would be caught on the wrong foot. Yes, what is Suman Sengupta doing here? You are appearing for whom?
No, state millet.
And for private respondent 6 and 7.
No?
Private respondent number 6 and 7.
Very.
My lord,
But may I just indicate only one thing? In the last occasion, there is a specific direction passed by this court that we have to place the report by examining 2 mobile numbers. The forensic report. In the last occasion, Millet, we have done it.
You have done it.
But there is a difficulty, I tell your lordship. The specific direction of this court to produce the same by way of a sealed cover. Sealed cover is not there. The report is
No, we direct the learned advocate
Right.
to examine the 2 mobile phones and submit a report in a
on the seal cover. The report is here without the seal cover. That is the whole difficulty.
my lord,
To be very honest.
one thing, my lord, on that day, my lord, this honorable
No, we
court,
will hear 2
no, my
things
lord,
from you.
directed me,
We will hear.
directed me to file, my lord. Lordship kindly have a look into internal page 3. Liberty is granted to appellant to implement the criminal investigation department West Bengal as respondent by filing an appropriate application. That application I filed, my lord. That is can 2. My lord, your lordship kindly dispose of that application. And my lord, another thing, my lord,
Mr. Sengupta can appear for that.
Yes.
and another thing, my lord, during the pendency of the appeal, pursuant to the order of the honorable single judge, 1 portion, my lord, I file an application before the learned Chief Judicial Magistrate Asansol for, my lord, police protection. My lord, pursuant to the judgment of the honorable Supreme Court, the learned single judge directed me to file an application for police protection before the learned CJM Asansol. I filed that application. During the pendency of this appeal, that application was rejected. My lord, I want supplementary evidence.
Rejected in that even.
No. That
Another
is
phase of cause of action.
not
It is not in the scope of the
your lord.
divisional
So
application.
that goes against you now, Mr.
My
Chattopadhyay.
lord, pursuant to the order of the honorable, my lord, kindly have a look into the impugn order. My lord, impugn order, kindly come to page 89 of the application.
That.
এই জাজমেন্ট নেই আছে
Page 79.
89. My lord, order start from page 87. Page 89, my lord, relevant part regarding, my lord, supplementary evidence.
87.
87 starts. Order dated, my lord, 6 February 2025. Page 89. Internal page 3.
ঠিক আছে. Yes, tell us what.
My lord, the learned Chief Judicial Magistrate Asansol will take into account the provision of the Witness Protection Scheme 2018 as the said scheme has not been formulated. Got it, my lord? Formulated by the state till date, the central provisions and or the guidelines set out in the judgment of Mahendra Chawla and others versus Union of India and others, such and such, be taken into account by the learned Chief Judicial Magistrate Asansol. A threat perception report be called for from the officer in charge of the concerned police station. Police authorities within 48 hours of the direction by the learned Chief Judicial Magistrate Asansol will submit their threat perception report. Learned Chief Judicial Magistrate will accordingly pass direction for providing necessary security as has been enshrined in the judgment of the Honorable Supreme Court or the Witness Protection Scheme 2018. That portion, my lord, I made an application during the pendency of this appeal before the learned Chief Judicial
That has been
Magistrate.
rejected.
My lord, that on the basis of the report of the police, which police I made an allegation from my very beginning for the murder of my daughter, my lord. My daughter is an assistant teacher, MSc Physics, M.Ed. My lord, for that reason, my lord, I made complaint, and for that reason, this writ petition, learned magistrate, one line order without any reason, my lord.
But why did you challenge this order? This was in your favor, no?
No. That portion, this portion, I am not challenging.
Come to that next portion.
My lord, I am challenging this order for my lord, transfer of investigation to another independent agency, not attached to Asansol. My lord, present petitioner also is a retired teacher. He lost the.
Why you are disbelieving? He said that, court said that Deputy Commissioner of Police in charge of Asansol North Police Station would monitor the investigation.
My lord, that portion I challenge, my lord.
Why?
My lord, I am praying for my transfer of investigation by CID. And that's why Honorable Coordinate Bench, my lord, leave granted to me to file a application to implement the CID as a party. My lord, fact remains that my daughter, my lord, was killed by the, my lord, some persons, and no investigation, case under section 304A, available section, not 304 part 2, part 1, 302, 304A,
So
accident.
Any final report has been filed? No, it is still under investigation.
Investigation.
Very good.
And for that is
investigation, as per the single judge's order, is continuing under the monitoring of Deputy Commissioner.
My lord.
Your grievances, it should be transferred to CID.
CID. And none will be prejudice. My lord, for that reason, Coordinate Bench kindly have a look into order dated April 21, 2025. Specific, my lord, observation of the Honorable Division Bench.
So we will go into that, but today let us, you
My
are
lord.
filing this, na?
My lord.
You have given copies to us.
My lord, copy this. But do একটা director দিয়ে দে
Mr. Chattopadhyay, learned advocate, appearing for the appellant, files a supplementary affidavit. Supplementary affidavit. Stop. Copies of the same have been handed over to the learned advocates appearing
Appearing for
I beg to appear for the respondent.
Original side.
arising out of Public Premises Act. What question is that I was in occupation under the tenant bond standard.
Oh, is it connected with that matter we heard?
We heard a matter yesterday regarding burn standard,
No, my lord.
and now they are trying to
Substantial-
evict you. 2015th of December 2000, there's an order for eviction which they are now trying to implement. Yes, we've heard this. We've heard a similar matter yesterday.
But then there must be what happens when there is a huge.
There are land parcels.
Different-
Yes,
Different
you're part of the tenant association. Made an.
I see. Lordship remembers.
My lord has gone through all the.
No, we heard it yesterday.
ওইটা কবে রেখেছি?
Point arts there for resisting, but here, my lord, my point, if I may indicate to your lordship in a very short frame. Here, my lord, what I am trying to say
So,
is
Mr.
that
Sen, we have fixed that matter, I think, on Tuesday, না? Original side একটা সময় দিয়ে করেছিলাম তো। আড়াইটার সময় না?
I do not know.
No, he was not there.
Moinak Bose is appearing
Moinak Bose was there. And Mr. Shoptangshu was
for the
appearing.
petitioner.
But the question here, my lord, I just tell you, lordship, very briefly, your lord, then your lordship will find out whether it is common question or not. Here, my lord, eviction order against burn standard. Thereafter, my lord, I have initially during the eviction proceedings, I wanted to have it regularized. That was rejected, whatever it is. Nevertheless, I challenged it by way of miscellaneous appeal. Appeal was dismissed. Then I started tendering rent in respect of the proportionate land under my occupation. Checks were being deposited to the port trust. It is true, my lord, they were not encashing it at that stage. Now, thereafter, what happened, my lord, these checks were being tendered by the then proprietor of the writ petitioner. My father passed away. They gave a letter thereafter that your check has been dishonored and you give some other mode of payment. That was in 2022. After that, I issued fresh checks from November 2022 till today, and they are encashing the checks. Now, what is the most interesting thing is that, well, why they started encashing the checks? Because in the meantime, this burn standard
Went
has
into
been
liquidation.
struck off from the register of companies. There is a resolution plan which was approved by the NCLT, where this amount of 7 crores payable to Port Trust was part of that plan, and Port Trust has received that amount from burn standard.
Already received.
Yes. So their claim against burn standard stood completely settled. The decree which they obtained against burn standard was adjusted by way of this money being accepted, and then they started accepting fresh money from me.
When the order of eviction, you.
Yes. After that order of eviction, my lord, they have actually settled with burn standard, accepting the money, started accepting fresh check from me. So my relation with them is no longer through burn standard. I have a separate jural relationship from November 2022 by tender and acceptance. Because their previous claim from burn standard was completely over, settled. So therefore, my case was, Lord, you cannot take recourse to that order of eviction and execute it against me.
Now, what they have done, now put
They
it
have
up.
put the padlock in
Same
2025. After accepting money, and even after that,
Mr. Sen once, sorry.
Have they put that land into auction?
they are now putting, my lord, they will be taking steps. They have already putting the movable items
Kartik,
which are there. They have put it
সাইডের
into
ওটা
auction.
কবে ডেকেছি?
So the next stage is the land.
ওই যে কালকে সপ্তাহ।
Well, I am today, my lord, only
Very
praying this much, my lord, no third party interest should be created in respect of that land. And my lord, that auction proceedings for the movable properties, that should your lordship, my lord, stay for the time being. Otherwise, my lord, that section 6 proceedings, if it goes on, then my lord, my writ petition will become infructuous. The learned judge proceeded on the premise that I am asking for restoration of possession.
We have heard Mr. Sen, learned senior advocate.
May I,
appearing.
may I respond?
বলছি তো against order টা please.
Appeal allowed.
Mr. Sen, learned senior advocate appeared. So that you can go to immediately Supreme Court after we release.
Very fast.
Don't take any steps.
But I
Don't take steps till the 22nd.
prefer
Those
going
steps.
to the single bench for
Don't
final
take
decision.
steps. Well, he participated in the eviction process, lost till Supreme Court.
I said that.
Now he's saying, he said so. Thereafter, you have accepted rent.
And you have said you have not
2022,
said
you're accepting rent. I could not hear, Miss Justice. You're accepting rent from him from 2022. I said in a letter, whatever you are paying without prejudice to our rights and contention. Now, if you are willing to pay, you pay it. So that is not, so it's clear. Yeah.
Yes, দেখো next. 6 এ কি আছে? দামোদর ভ্যালি।
For the petitioner respondent.
I am for the appellate, but I will be very candid to your lordship. But kindly only take up the section 5 application.
Yes, Mr. Mitra, who are you appearing for?
I am
Sir, I will be asking for time.
But I am.
In fact, both of us have
But both of us, I also received the brief. Respondent number 3. I am ready with the matter.
That always is.
As always.
So we are not.
I have, in all my years that I've assisted you, I've never seen you not ready.
My lord, I am not objecting to section 5.
There is only 9 days.
No, I'm not objecting. My lord, only thing. My lord,
Evidential services file we kept on record.
my lord, it has been made. My lord, I have also preferred an appeal. I have filed. My lord, what is no, my lord, what has happened is it has made. It has been.
Yes,
We have not challenged. We have not challenged the order. It has been made prospective. It is the case of prospective overruling. What, my lord, it has been declared as ultra vires, but it has been made prospective from that date of the judgment. My lord, only to that extent I have challenged.
So
Only-
ultra vires, you are
My lord, obviously,
accept
my lord,
ultra vires, then the entire statute goes.
There is not
Are
one
prospective.
provision, my lord, one provision, my lord, it has been made one
Well,
provision.
I tell you, Lordship,
It's a
very
rest.
interesting point involved. A particular provision in the Regulatory Commission's notification has been declared ultra vires on the ground that this particular provision does not contain any indication as to how it is to be operative, particularly being contrary to the contract between my lord DVC and my lordship. Now, my lord, so far as that is concerned, this issue is before your lordship is as to the not only the vires of the section and to what extent, my lord, the contract between the parties is to be read. My submission will be that this here in this in interpreting, my lord, clause 4.4, question of public interest is involved because it is not one consumer only. It is in respect of everybody. So, my lord, a larger aspect of the matter has not been considered by the learned judge. That will be the point which I shall urge before you.
We had, my lord, I tried to assist in my whatever way.
Wait, Mr. Chakraborty, if you want to file, you
But I
file.
have filed, my lord. I have
So
filed.
give the
A
number.
my lord, it is given in this. I am asking for a bigger page. This I'll not hand over. I am giving the number.
Then don't hand over, speak.
Mat 926 of 2025.
ওই ম্যাট 6 আর এইটাকেও তাহলে সেদিনকে ওর সাথে দিয়ে দিও।
Lord, I have not come across an order in respect of which all parties are agree.
No, please.
This is something very new to me.
Lordship, if I'm not wrong, in a matter, Lordship had appeared before
Okay,
Justice Pratap. No, my lord, whether this issue, Mr. Mitra also appeared. Prospective ruling was discussed whether a guardian can file a writ petition or not. No, my lord, this issue.
That issue will arise anyway.
All right, it will appear on that date.
6th
Lordship.
Yes,
6th August.
হ্যাঁ বলেছি অরিজিনাল সাইটে সোয়া 3টে ফিক্স করে। Next, 7.
I am for the respondent.
Respondent, please for the
I'm appealing for the appellant, my lord, intervener appellant. Lord.
intervener appellant.
Yes, my lord, in the court below, my lord, I have taken up an application for admission of party, my lord, and my lord, my application has not been considered. The case make out in the writ petition is that, my lord.
দাঁড়া।
Order impugned is at page 16. May I come to the order impugned first?
Or everybody is appearing?
Not for the state, yes, my lord. You know.
I'm coming to the order impugned.
Just a moment. So you have been added as a party.
No, my lord, this is Mr.
Lordship, my application was allowed.
His
and I was
application
added.
was allowed and he was added as a party.
Just.
And my lord, the can 2 is my application.
আচ্ছা একটু
এখানে নয়।
So, who wanted to be a party? Can 2 was filed by whom?
Filed by the appellant, United Order of
But
United
you-
Order and Supply.
You appeared for Minicon.
Lordship.
For the petitioner, you appeared.
Milord, yes, but Minicon is supporting the appellant even, Milord, because they are the sister
তো
concern.
তো অন্য কাউকে দিয়ে ফাইল করো। Now,
May I press my?
so you will be challenging the work order given to.
Milord, the
given to
work order has not yet been issued.
Has given.
Now, let us understand. Writ petition has been dismissed.
Yes.
Writ petition dismissed.
Yes.
Now, if writ petition is dismissed, if you have a separate cause of action, who prevents you from filing a writ petition?
Milord, this I have filed
No,
the
no, let us understand. A writ petition was filed by Minicom.
Yes.
That was dismissed.
Yes.
So the court said, when I am dismissing the writ petition, I don't require your assistance. Now, if you say that you are aggrieved by his contract, you should have filed an independent writ petition.
This is
saying that my addition was not allowed because you had dismissed the writ petition. Kindly consider my challenge. Finished. Why you are coming to appeal court?
Milord, that will be a multiplicity of proceedings, Milord.
How multiplicity, Mr. So then this becomes multiplicity.
This is also multiplicity.
চিন্তা করে
You have a right, you have an independent right to challenge the action or inaction
Milord,
of the authority.
first of all, this is Milord,
just
if
explain
there is,
what- no,
if
no,
this is
Mr.
an expressive illegality,
Mr. Just, you are not the writ petitioner.
I'm not the writ petitioner.
Writ petition dismissed.
Yes.
Your argument would be that had I been present, had you heard me, then you would have allowed the writ petition. This would have been your submission.
Yes.
Before us.
Yes.
So we say that question of agitation of that issue, file an independent writ, take separate grounds to that effect, and move the writ court, dismiss, then come to us.
Milord, that will be all.
Minicom করেন।
Milord,
Your brother has also not
that
done.
will delay entire situation, Milord. Kindly consider the case.
Minicon could have preferred the appeal.
Milord,
Minicon could have preferred the appeal.
Minicon could have preferred
As you have a right to file the writ petition, fresh writ. You've preferred the appeal.
Then, Milord, kindly consider that there is an ex facie illegality. If there is an ex facie illegality and irrationality in the administrative action, then, Milord, there are three judgments on this.
So
Milord,
the
there are three
grounds which
principles. One is
No, we are wanting to know the grounds which you will be taking. Your addition has been dismissed. You are aggrieved by non-addition. We allow your suppose we allow your application. Appeal, we set aside the dismissal of the addition of party application.
Yes.
Then what course will be left to you?
Milord, then this appeal, I can prefer this appeal even before your
Without filing a writ
Milord,
petition.
Milord, if a person is aggrieved by
We will record that as the writ petition was dismissed, the addition of party appeal.
Milord, if
Just
there is
listen
any
to us. Listen to us.
illegality, my lord.
Listen to us. Since the writ petition was dismissed, we don't. Your application for Section 5 was dismissed for that reason.
Application of Section 5.
Addition of
Milord, addition of party.
We will observe that.
Milord, kindly consider, Milord. This is Milord on three grounds. Milord, kindly consider this is the law laid down in Milord, the Reliance Airport Developer Authorities Private Developers versus
How
Airport.
we will consider first satisfy us what is the wrong in the order. Tell us.
Yes.
Your order is 4 lines. Kindly say why it is wrong. Since the writ petition has already been dismissed, no further order is required to be first in the kind. Same is dismissed. What is the wrong in this order? Tell us.
Milord, first in the when this writ petition was considered, there is an illegality in the order, Milord. Kindly consider, Milord. First, I read the order impugned, and Milord, come to my part. Vishnupur District Hospital, a tender was floated by the authority in the year of 2020. And my lord, writ petition was filed by the erstwhile contractor seeking a direction upon the hospital to consider the representation and releasing him from the contract. That was on the existing supplier, my lord. And my lord, this order is annexed with this stay petition at page 56. And thereafter, my lord, my lord, kindly come to the paragraph 7. 6.
If that writ petition direction was issued for consideration of the representation.
No.
This Swapon Kumar.
Yes, consideration of the representation.
Who is Swapon?
That is the existing diet contractor, my lord.
Mr.
No, he is not.
Oh, the one who was given the
L1 bidder existing diet contractor.
So what was the tender period?
Tender period was 3 years.
Acha, when was he given the work order?
My lord, that is at page 146, my lord.
Acha, tell us tell us what you submit, what you are submitting.
My lord,
Then paragraph 7, you asked an application.
From, my lord, relevant portion is starting from the paragraph 6.
Yes.
According to the petitioner, the contractual period has ended and authority should float a fresh tender so that petitioner as a prospective bidder could participate in the same. An application for addition of party has been filed by Shiva Prasad Banerjee, who is now respondent number 7 in the instant appeal and who was L2 bidder in the erstwhile tender process. Offer has been given to the applicant to seek his willingness to perform his work of supply cooked diet. This applicant is agreeable to accept the proposal of the authority. Next, my lord, the court finds in the presence of the private respondent is necessary for the purpose of then his application for addition of party was allowed. The learned advocate representing the state respondent submits, that is at page 10, upon instruction that the authority has already offered the contract to the second lowest eligible bidder of the subject tender, and L2 bidder is agreeable to work on the same term and condition of the tender document. Accordingly, the authority intends to accept the proposal of the private respondent. Upon hearing the parties, it appears tender process which was initiated by the authority in the year of 2020 continued till contractor who was engaged expresses inability to continue with the contract. My lord, my first submission, and my lord, I am asking myself, the tender is a offer. I have not participated. Minicor have not participated in the tender.
You participate.
I have not even participated.
Appellant also not.
I have not participated. My lord,
You have not participated.
my lord, because that was the tender was finalized in the year of 2020.
Right.
And the contractual period was 1073 days, my lord. I have annexed the tender details even, my lord. I shall come to that.
Did you challenge you?
My contention is that they should have issued fresh tender, fresh NIT should have been floated, my lord.
Exactly. That prayer has been rejected of Minicom. If you file another writ petition, your fate may be the same.
Yes.
Then you can come and appeal. You will make all your argument before the writ court that these were the conditions, this was the period of contract. How can
My
you
lord,
revive a thing which is of 2020 without issuing a fresh tender?
This has already been.
Following because the successful as mentioned, United Order.
And my lord, further the learned royal judge has already hold that there is no illegality.
Order applied. Group for supplying.
এ তো ইউনাইটেড অর্ডার সাপ্লাই তো হি
Following bidders were successful. United Order and supply.
He was you were L2 then?
L3.
My lord, I am not participant.
Page 6 of your stay application.
What sheet?
That
is the misguiding statement. That was earlier tender. There was a tender in 2018.
That is earlier.
There was a tender in 2018 where my appellant participated and he stood L2. That was cancelled.
Thereafter, 2020, fresh tender was issued. Appellant
did not
participate. And my client participated and stood L2. That is why the work order has given to my client as the L1 bidder does not want to continue. So L2 bidder was given.
Then there would have been a fresh tender.
Lordship, one thing, Lordship, what happened, Lordship? Because
Yes, my lord, that was.
Lordship, I'm coming, Lordship. What the point Lordship raised, that is another question, that is a law point, whether he can raise this point or he can subject. But Lordship, there is an order of this court that state government has to correct the rate and thereafter issue fresh tender. Without correcting the rate they have prescribed earlier, the authority is not allowed to float a fresh tender, because also the state government has submitted before this court that they will. Lordship, there is an order of this honorable single bench, but till date they have not rectified that rate, so they have not issued any fresh tender in any hospital in West Bengal. All hospitals, old rate is going on, and the old bidder are going on because the government has not framed the rate chart.
বুঝতে পারছি না এখানে necessary in the safe petition. Your addition of party application has been dismissed. You listen to us, then open your mouth. Your addition was dismissed. At the same time, writ petition was dismissed.
Yes.
Huh? This is a fact.
This is the fact.
You were also not a participant in the consent tender process. This is also a fact.
This is also a fact.
So we will say that in such circumstances, you were neither a necessary party nor proper party to be added in the writ petition. However, we will grant you leave to challenge that in a fresh writ petition.
My lord, the respondent number 8 is the writ petitioner, my lord. He is present in the court, my lord. And
yes.
And my lord, they are supporting this appeal, my lord. Although it's in the area of the, my lord.
You are not understanding what we are trying to say. Please apply your mind. Please apply your mind.
Give it back.
Do that. File your report.
And you could not even have been.
And my lord, in that event, my lord,
Because it has not been
stay of
paid to your
That
lordship.
event you have to wait when the affidavits are complete and come and take that.
my lord, in that event, my lord, the stay of the work order is required to be issued, my lord.
Stay of the work order. At
And the
whose
patients will
instance?
go hungry.
Have Minicom preferred an appeal before us?
Lordship. Minicon is supporting Milord only in the area of the respondent, Milord.
The present
Milord,
appeal has
only
been
one
preferred.
thing, if I may, Milord, just indicate. I was, Milord, keeping silent. Can 2 was never served on the state, and Milord, it is for the advocates, learned advocates, to say when Can 2 was filed. Can 2 could not have been even pressed. They did not press it, and it could not have been pressed because probably it was filed on the day before the day of disposal.
Same advocate.
I stand to be corrected.
Yes.
No one appeared on their behalf.
No,
Same
he had said, he had owned up, because this Can 2 was on the list. I did not I did not have a copy. I am not sure whether the other party had a copy. Now this query fell from the honorable judge that what is Can 2 about. My lord, the learned
Milord,
advocate
Can
for the
2
may I please complete? Yes. So, my lord, the learned advocate for the writ petitioner came and said that Can 2 is for addition of party. Sorry, he said that Can 2 is another connected application, but he did not press it. Number one. Number two, if I am not wrong, he is there to correct me. He had filed Can 2 just the day before. So it was less than 24 hours by when the matter was listed. It was never pressed, never served.
Yes. The present appeal has been preferred. Yes, 8.
Number 8, my lord, I am praying for my lord 1 day accommodation.
Not today, next.
My lord, I am for the private respondent, my lord, but yes, tomorrow I have some personal difficulty. Make Monday.
Tomorrow kiss person.
That's I have personal.
All right, next Thursday. Yes, next Thursday. Yes, 9. দেখি ফাইলটা দাও হেভিয়াস কর কেউ নেই ও এটা বলছো ইয়ে করতে হবে কার্তিক কেউ আছে দেখি দেখি কেউ আছে 9 who is for the petitioner yes
led by Mr. Owen Bhattacharya. I'm praying for not.
My lord, this is third time, my lord. Last occasion also they prayed for time, my lord. This is third time. This simple matter, my lord. Habeas corpus
habeas corpus
is not maintainable in.
Aha, we couldn't complete the habeas corpus list yesterday. That is why you have placed. We'll take it up on again on Wednesday.
Great.
Yes, next Raku. Yes.
I'm for the petitioner.
I'm for the petitioner.
I'm extremely apologize. Earlier occasion I am not appeared before this court for
Oh, earlier occasion you were not there.
health issue, my lord. Not say affidavit service. Lordship, in this matter, 27 June, 27 May 2025, the girl was missing, and thereafter a case has been
Yes,
registered.
Mr. Mukherjee.
Well,
Any
this is the
development?
report, my lord. My lord, report.
Any development?
Yes, we have, my lord, we have done all the necessary formalities, my lord, that is required, my lord.
The mother of the principal accused has been arrested and thereafter taken granted bail by the trial court.
What is you are your daughter?
Yes, Lordship.
Your daughter?
Lordship.
Minor?
Minor.
How
17
many?
17 years, 6 months.
And she has left her house, went missing. Along with whom?
Along with one principal accused Afsar Ali.
Afsar
Ali, and the page
So
number.
you lodged a complaint.
I have lodged a complaint, missing diary, and thereafter one FIR has been lodged, and thereafter subsequently the mother of the principal has been arrested.
Mother of that Afzal. Mother of Afzal arrested.
Yes, Lordship.
Then what happened?
Then nothing. Police does not recover with the victim girl.
So Afzal doesn't have father and brothers.
Yes, or Lordship. No step has been taken by the constable.
Mother is still in custody.
Lordship. Same day the mother has granted bail.
Mr. Mukherjee, what is your police doing?
Not seize, my lord, from page 2 onwards.
Brother is there, father is
When you
there.
analyze the CDR, it was found the suspect number had been switched off since 29th May. And the last recorded location is 9/2 Rajkishore Roy Chaudhary Lane, AJC Bose Road, Kolkata, such and such. The number had frequently communicated with the victim's mobile number, indicating a prior romantic relationship. SDR confirmed that the number belonged to the prime suspect. The IMEI number of the suspect device was extracted and forwarded to OC SOG Malda.
Mr. Mukherjee.
We have done everything.
You have done.
47 days the girl was missing. Lots.
Your police cannot arrest one person. Huh? This way, Mr. Mukherjee, you said on 28th June 25, we have sent letters to different states.
Yes.
You never get the guard. This is not how will you understand?
Now, my lord, the IO had now, my lord, as of now, as per instruction, my lord, the IO has gone to Mumbai, my lord, acting on a tip-off that they might be there. This
That you have
report
not
came to us.
written, that you have not written here.
No, this report came to us on 8. Today they have informed that they are acting on a tip-off. Now the present location is at Thane, Mumbai. So our team has left.
Mr.
Imdadul Haq.
Mr. Hawk, learned advocate appearing for the petitioner submits.
Okay.
Yes, 11. You are there. 11, who is there?
My lord,
There.
my lord, I appear for the petitioner. My affidavit of service.
Affidavit of service, yes.
I appear for the private respondent number 7, 8, 9, 11, and 13.
7, 8, 9,
11, and 13.
11, and 13.
Kara.
Yes, what is your
My lord,
case?
facts of the case. I am a father of a minor daughter. She had left for a tuition on 10th of May 2025. Thereafter, she is not found.
You are the mother.
I am the father.
Father, what is the age of your daughter?
My lord, 17 years.
So she must have fled away with somebody.
Previously
My lord,
fled
she
away.
has been. My lord, she. My lord.
Yes. Yes, madam.
My lord, the girl, the respondent number 7, my lord. The respondent number 7 had lured this girl, my lord.
Hmm.
And now she's been found missing.
So do you know where
Still a minor.
your daughter is
My lord, she
residing?
had left for tuition.
Uh-huh.
She had left for tuition on 10th of May 2025, my lord.
10th of May.
Thereafter, she was not found. I made a complaint.
Hmm.
An FIR was registered on 12th of May 2025, my lord.
So on what basis did you make Bikash Pal a party? He's an accused in your
My lord,
complaint.
he is the person who was luring my daughter, my lord.
Oh, I see.
And respondent number 8 is the father of
My lord,
the respondent number 7.
prior to this incident, 10 days before, we have rescued the girl where a similar case was registered regarding missing and kidnapping. It was lodged with Kodlani police station. My lord, we have recovered the victim. Victim was produced before the learned magistrate. Before the learned magistrate, she said, "Ami ragaragi kore didimar bari chole giyechhilam." Then father took custody of the girl. Within 10 days, he again fled away with this boy.
You are the boy.
I appear for the boy, the father of the boy, and a few local residents.
Then where is she? Why you are not returning the girl?
She was in. She and the boy and the. Your Lordship, the girl and the boy love each other. Now, this time she is not been kidnapped by the boy, Your Lordship.
So how you are keeping her in your place?
She is not with us.
She's not residing.
She is
with
not
you?
residing with us.
Then where is she?
We don't know, Your Lordship. She is not residing with the boy, Your Lordship.
So you are saying you are having a love relationship. You do not
Lordship,
know where you are.
Now we do not know, Your
Then
Lordship.
we will ask the
My
police
lord.
to arrest you.
Your Lordship.
Arrest you.
Your Lordship, because she is not with us.
The police will act accordingly. You will sprite it out immediately.
My lord, we have
questions.
My lord kindly considers the address of the petitioner as well as the respondent number 8, 7 and 8, my lord. They reside in the same village, my lord.
And what about the earlier incident?
My lord,
You don't know.
my lord.
You know.
My lord.
Let us try our luck in High Court. You must have told your client.
No, my lord. That
Then
is not
she
the case.
fled away because
That is indeed not the case, my lord.
Then, madam, you will face such questions. You are an advocate in High
My
Court.
lord, I wasn't aware, and
Be careful next
lord,
time when
my
you
lord, next
accept
time,
a
my lord.
brief. You must consult with your client.
My lord, I shall.
Now, this is an embarrassment on your
My
part.
lord.
The girl had been
Indeed it
recovered.
is.
Yes, show us. Report ta kothay? That where is her statement?
that was earlier. That was in an earlier report. Maybe with the annex with the report, I would show to your lordship.
Now, since she left, but Mr. Mukherjee, she has left. She was recovered.
Yes.
That does not mean you will not recover her for the second
No,
time.
we will recover. My lord, what happened? This time, since they were arrested on the basis of the my lord, CDR and SDR.
Who were arrested?
The boy in the previous case we have arrested. He was
Same boy.
Yes, he was released on bail. Then the father of the girl took the father into custody, in his custody, and the boy was arrested. Now, my lord, what happened? This time they have become clever. My lord, they are not using the mobile phone. They have kept the mobile phone switched off. We have collected the CDR and the SDR. And my lord, thereafter, what happened? We have found a tower location at Ghaziabad. We had been to Ghaziabad, but by that time, my lord, the mobile again went switched off. My lord, will ask the respondent number 7 to cooperate with the investigation.
That means
Why is fleeing
that's
away
the
there?
reason. That is the
Then
reason.
why
He's
you are
absconding.
why you are running away?
Lordship, we are not running.
Listen, sir. Either you talk with your client that to give the whereabouts of the girl. It is unbelievable because the police has found a tip. They went to Ghaziabad. So you must have been there with the girl. You better take instructions. You will be having problems.
I'll take instructions, Your Lordship.
Join and cooperate with the investigation.
Miss.
My lord, Parnaz Naseem. Parnaz Naseem.
Miss.
in person, husband of Chandri Alam expired.
Oh my.
Item number 16 and 17 may be adjourned for 2 weeks. When his clerk informed me, I am appearing for the state and Alam is appearing for the.
মার্ক করে রেখো তো 16 17 2 weeks adjournment একটু 2 weeks লিখে রেখো মামলাটা ডাকলে তখন আজকে তো আর ডাকবে কিনা দেখো মিস্টার মুখার্জি প্রেয়ার গ্রান্টেড ফোনটা বার করিস
Sing.
I have made a mistake. I have made a mistake in the earlier matter, my lord, habeas corpus matter, my lord. I have made a mistake. In
What
the
mistake?
habeas corpus matter, my lord. My lord, of the same police station, another girl, Aparna Maulik, was recovered and given to the custody of his father. I got confused and submitted that this girl was also recovered earlier. Same PS, same age.
কে নিয়েছে অর্ডারটা? তাহলে এক কাজ করো, ওটাকে অর্ডারটা রিকল করে লিস্টে থাকুক সামনের বুধবারে। You please inform your other side that the matter will be taken up next Wednesday. Ask him to be. আচ্ছা ঠিক আছে, ওই যে অর্ডারটা পাঠিয়ে শুনো, অর্ডারটা যেটা ওটা পাঠিয়ে দিও, ওটা কেটে দেবো আমি, সাবমিশনটা কেটে দেবো।
We hope we will be able to come with a better result because today I have noted the phone number of the advocate with whom the accused is in contact. I have supplied to my officer and said, take this CDR.
Okay. Yes, call the list. No, respond. কার্তিক, এই যে সামনে বুঝে রয়েছে না, yes.
But may I place first the judgment under appeal? Well, it starts at page 90 of the paper book. The Lordship kindly turn to page 92.
Yes.
This is a petition for grant of probate or letters of administration or succession certificate. Briefly stated, the fact of the case is that Muadev Lal Saw, the died testator, was permanent resident of Kagada, Dewanganj of Barampur in the district of Murshidabad within the jurisdiction of this court. He died on 20th October 1962 while he was residing in the Kagada Dewanganj. The propounder petitioner Kartik Lal Saw is the son of died testator Muadev Lal Saw, who died leaving behind one son Santosh Lal, two daughters Saraswati and Sadhana. Santosh Lal Saw, Saraswati and Sadhana are the opposite party number 1, 2 and 3 respectively. Muadev Lal Saw executed and registered his last will on 15th of October 1960. He appointed Kalipada Sahu Vishnupada Saha as executor of the will. Then the executor Kalipada Sahu refused to file probate application, and as such he is made opposite party to this case. Then executor number 2, Vishnupada, died. The petitioner Kartik Lal filed a petition for probate of the will in the year 1975 in the Court of District Delegate
Murshidabad. That petition was registered as probate case number 64 of 1975. It is further stated in the petition that there was talk of compromise, and as such the petitioner did not proceed with the said probate case. There is no other petition pending for probate or letters of administration of the will. So the first application for probate was not proceeded with on the alleged ground, my lord, that there was a talk of compromise going on. Then kindly turn to page 93. Petitioner Kartik Lal Sahu again filed a petition for probate of the will in the Court of District Delegate Barampur, Murshidabad, and that petition was registered as testamentary case number 56 of 89. OPs appeared in the said case and wanted to contest the petition. So after the first petition, which was filed, my lord, in 1975, this second petition was filed in 1989. OPs appeared in the said case and wanted to contest the petition. The petition became contentious, and as such, the same is refiled refiled in the court of the District Judge Murshidabad. The petition is freshly registered as testamentary suit number 14 of 1991 in the court of the learned District Judge Murshidabad, who has transferred the same to this court for disposal. The opposite parties are contesting this petition by filing written statement denying the material allegations. During pendency of the suit, Kartik Lal died. His legal heirs are substituted as petitioners. The execution of the will is denied. It is stated in the written statement that Mahadev Lal lost his physical and mental ability to execute the will. The will is manufactured and fabricated. The Mahadev Lal had been suffering from various ailments during last 4 or 5 years of his life. Then Kartik Lal, being his eldest son, took that opportunity and managed to have the will executed and registered by Mahadev Lal Sahu, dominating his will. It is further stated in the written statement that Mahadev Lal Sahu belonged to Mitaksara school of Hindu law, and as such the property included in the will was the co-personary property. Mahadev Lal Sahu has no right to execute the will in respect of such co-personary property. It is also alleged that the petition is barred by limitation. As per case of the OPs, petitioners are not entitled to get any grant of probate or letters of administration. Then the issues are framed 6, 7, 9, 10 kena. Baki guna kiyala. Other issue guna kiyala. Is the suit maintainable in its present form? Has the will been properly executed and attested? Is the will genuine? Has the executant of the will physical and mental capacity to execute the will? Is the petitioner entitled to get the order of probate of the will? Then issue number 1, admittedly died. Testator Mahadev Lal Sahu was the resident of Khagra, Devanganj, Baharampur, in the district of Murshidabad within the jurisdiction of this court. He died on 20th December 1962 at his residence at Khagra, Devanganj within the jurisdiction of this court. So no question of mental ability is raised by the adversary. This issue is therefore decided in favor of the petitioners. Then the other issues, all the issues are taken up together for convenience of discussion and in order to avoid unnecessary repetition. This is a petition for grant of probate or letters of administration of the will dated 15th of October 1960, executed by the died testator Mahadev Lal Sahu. The will is a registered one. Will is defined in section 2 of the Indian Succession Act as will means the legal declaration of the intention of the testator with respect to his property, which he desires to be carried into effect after his death. Probate has been defined in the same section as under. Probate means the copy of a will certified under the seal of a court of competent jurisdiction with a grant of administration to the estate of the testator. The learned advocate for the objectors argued at the very beginning of the hearing that the testator Mahadev Lal belonged to Mitaksara school of Hindu law, and as such the properties included in the will was the co-personary property, and he had no right to execute the will in respect of such co-personary property. So the question emerges in this case as to whether this court can go into the question of the title of the testator in the property included in the will. This question is settled by a catena of decisions by the Honorable Supreme Court, by our Honorable High Court on different occasions. In this context, we may refer to the decision of the Honorable Division Bench of our Honorable Court, reported in 2000, Volume 1 CLJ at page 640. It is held by this Honorable Court that in an application for grant of probate, it is not open to a trial court to go into question relating to title. Whether the testatrix had the title to the property or not, basically is a question to be decided by a civil court, seized of proceedings relating to the adjudication of a civil dispute between two sets of adverse parties, one set claiming title and the other denying or repudiating the same. One such method of doing so is the filing of the civil suit in a civil court. A civil court seized of a civil suit is fully entitled and capable of going into all simple and intricate questions relating to the title in respect of the property, whether possessed by the testatrix or not, with all its effects and consequences in the light of the will executed by the testatrix. The position, however, is different when it comes to the probate proceeding, because the grant of probate in respect of the will of a deceased by itself is not any adjudication by the court with regard to any question relating to title, as the grant of probate by itself does not confer any right or title upon any person in respect of any property, since all such questions are subject to adjudication by an appropriate civil court. The scope of probate proceeding is limited only to decide as to whether the testatrix at the time of execution of the will was physically and mentally fit in such a position and state of mind as to understand that she was executing a particular will in a particular manner, and that the contents of the will were properly understood by her. If the court seized of probate proceeding is satisfied about such testamentary capacity of the testatrix, it shall not go into any further question and grant probate of the will. What follows thereafter, when the will is being put to action or might be administered, is not a matter for consideration of the court's seized of probate proceeding. If a person asserts his right based on a will for which the probate has been granted, and in the other dispute such a right, the same would form the subject matter of an adjudication by a civil court in a civil suit. When we talk of testamentary capacity, clearly it does not include the title of the testatrix in the property in question as such, but only relates to the capacity of the testatrix physically and mentally at the time of the will. In view of this aforesaid decision, I am unable to accept the argument advanced by the learned advocate for the objector that Mahadev Lal Sahu had no right to execute such will. Mahadev Lal, who possessed the suit property, died on 20th October 62. He had taken two wives, namely Rajlakshmi Sahu and Dayamoi Sahu. Kartik Lal Sahu, Santosh Lal Sahu are the two sons. Sadhana and Saraswati are the daughters of Mahadev Lal, born out of his first wife Rajlakshmi. Second wife Dayamoi had one son, Tulsi Lal Sahu, since deceased. Santosh, Sadhana and Saraswati are contesting this petition as objectors. Kartik Lal Sahu is the eldest son. He is the executor of the will. The will is a registered one. At the time of will, both the wives Rajlakshmi and Dayamoni were alive. By the will, Mahadev Lal had given co-scheduled property to his first wife as life estate, co-scheduled property to the propounder or petitioner Kartik Lal absolutely, co-scheduled property to his second son Santosh Lal as life estate, co-scheduled to his daughter Saraswati as life estate, scheduled property to the daughter Sadhana in life estate, and scheduled property to Tulsi Lal absolutely. He did not give any property to Dayamoi by the will, but he gifted some property to Dayamoi by dint of separate registered deed of gift on the same day. All these things are clearly stated in the will. It is further stated in para 2 of the will that Kartik Lal and Tulsi Lal would acquire absolute right title interest in the above mentioned property. Rajalakshmi, Santosh Lal, Saraswati and Sadhana have got no right to transfer the property absolutely. The issue of Rajalakshmi will get absolute right title and interest in the property which is allotted to Rajalakshmi by this will. It is also clearly stated in the will that on the death of Santosh, his issues will get the property allotted to him by the will absolutely. Further condition of the will is in the case of death of Santosh issueless, then his properties will be inherited by Kartik Lal or in his absence, his sons. There are other conditions also in the will. The objectors have challenged the legality of the will as well as the execution and registration. In order to prove execution and registration of the will, 6 witnesses are examined on behalf of the petitioner. Kalipada, executor of the will, is examined as PW1. Kartik Lal, propounder of the will, is examined as PW2. He is also executor of the will. Vishnupada Saha, another executor of the will, died. Kausik Lal Sahu, son of Kartik Lal, is examined as PW3. Niranjan Bosak, Kuntal Sahu and Utpal Pal are examined as PW4, 5 and 6. Kuntal Sahu is another son of Kartik Lal. Kalipada Sahu is examined in this case on commission. He has deposed that the will as written by Surendra in presence of Mahadev Lal and attesting witnesses. At the time of will, Kalipada Sahu was present. He is cross-examined in full. From evidence of PW1, it is further revealed that Bimal Kumar Chandra, Shankar Das Rai, Pandit Hiralal, Pannachand Buddha, Satish Chandra Ghosh, Balaram, Advocate Umapada Pal and Pasupatinath were present at the time of writing of the will, and the will was written as at Khagarai, Dewanganj Road. Admittedly, Kalipada is the relative of Mahadev Lal. After writing of the will, Mahadev Lal himself read over the will and signed the same in presence of the attesting witnesses who saw him to sign the will. Witnesses also signed the will in presence of Mahadev Lal. He has given the evidence to the effect that at the time of the will, Mahadev Babu possessed good health. Kalipada Sahu has deposed that scribe Surendranath Bhaumik and attesting witnesses Pasupatinath, Balaram, Shankar, Satish Chandra, Bimal, Pannachand, Buddhadev and Umapada are already dead. All the attesting witnesses are dead. Thus, it is established that all the attesting witnesses and the scribe are no more in this world. The witness has identified the signature of Mahadev Lal Sahu and all other witnesses, including the scribe. The signature of Mahadev Lal Sahu on the will are marked Exhibit 1 series, and the signature of scribe and the attesting witnesses are marked as Exhibit 2 to Exhibit 2 by 8 during evidence of PW1. PW1 is tested in cross-examination at length. I find nothing to hold adverse regarding the execution of the will from the evidence of PW1. The will is marked as Exhibit 1 as per report of the learned commissioner who recorded the oral evidence of PW at his residence on commission. Kausik Lal, son of Kartik Lal, as PW3 has deposed that the will is produced from the custody of his father, and he has further deposed that there was talk of compromise, and as such the petition is filed lately. He has also deposed that Kartik Lal possessed good physical and mental health at the time of execution of the will. Niranjan Bosak is examined as PW4. He is an old man of 76 years. His house is near the house of Mahadev Babu. He has deposed that he had access to the family of Mahadev Babu before Well, I was reading from page 102 top.
162.
162 top. He has also produced one registered deed of gift executed by Mahadev Lal on 15th October 60 in favor of Dayamoi. It is a 30 years old document and the custody is proved. This deed is marked as Exhibit 5. Well, kindly, no, let me proceed, my lord. Then another registered deed of gift dated 26 December 63, executed by Kartik Lal, Santosh Lal, Saraswati, and others, is produced by the petitioner. It is also a 30 years old document. Its proper custody is proved, and as such, this document is marked Exhibit 4. From Exhibit 4, it is very much clear that Kartik Lal, Santosh Lal, Saraswati Sadhan, and Rajlakshmi saw together with the executor Kalipada Sao and registered one deed of gift in favor of Tulsi Lal Sao in respect of some properties included in the will. Since it is a 30 years old registered document, it bears presumptive value of genuineness as per section 90 of the Evidence Act. So, my lord, he is taking a view that since the will is 30 years old document, registered document, it has got a presumptive value of genuineness, which is absolutely wrong, my lord. So far as will is concerned, my lord, this presumption doesn't apply. I shall place my written notes, my lord. I have dealt with all this. Saraswati is examined in this case as OPW1. There is no denial of execution of this deed. This deed was executed on 26 December 63. Saraswati was married. There is clear admission of the will in question in the Exhibit 4. So it is very much difficult to accept the argument of learned advocate or the objectors that Saraswati had no knowledge about the will. Then next page, from Exhibit 5, it is clear that Mahadev Lal gifted some properties to his second wife, Dayamoi, by dint of registered deed of gift executed on 15th of October 1960, and the said was presented by Mahadev Lal for registration on 18th October before the registering authority. Mahadev Lal Saab put his LTI before the district register, Murshidabad, admitting the execution. From the will, it is similarly evident that Mahadev Lal presented the will before the district register, Murshidabad, on 18th of October 60 for registration, and he put his LTI on the date in presence of district register, Murshidabad, admitting the execution.
Same date.
From Exhibit 1 and Exhibit 5, it is very much clear that the scribe and the attesting witness of both deeds are the same person. PW4 is the neighbor of Mahadev Lal. He has deposed about the health condition of Mahadev Lal at the time of execution of the will. Advocate Paul Pal is examined as PW6. His son, Advocate Umapada Pal, his father was a renowned lawyer. PW6 had identified the signature of attesting witness Umapada Pal on the will. The signature is marked Exhibit 2/6 as proved by PW1. PW6 has also identified the signature of the attesting witness Balaram on the will. That signature was proved as Exhibit 2/7 by the PW1. Balaram Pal was the grandfather of PW6. Being the son and grandson of Umapada Pal and Balaram Pal, is competent witness to prove their signature. The scribe and attesting witness admittedly died long before the filing of the present probate application, and as such the scribe and attesting witnesses cannot be examined in this case. The will is 30 years old registered document. In this context, Darland advocate for the petitioner argued that it bears the presumptive value of genuineness as per section 90. Kindly mark this portion, my lord. I am challenging this finding. Is not controlled by section 68 of the Evidence Act. In this context, he has referred to a decision of the Honorable High Court reported in 85 Calcutta Witness 271. It is held in this aforesaid decision that in the case of a registered will, 30 years old and produced from proper custody, and the presumption arising under Section 90 and fortified under the more general provision of Section 114 thereof may be drawn, that it was duly executed and attested in accordance with the formalities required by the Indian Succession Act. Then Saraswati Sahu, the daughter of Mahadev, who is examined as OPW1, has admitted in cross-examination that Umapada Pal was present at the time of will. She has also admitted that Balaram, father of Umapada, is their neighbor. Such evidence proves that she was aware of the will. There is a long line of decisions bearing the nature and standard of evidence required to prove a will. Those decisions have been reviewed in an elaborate judgment by the Honorable Supreme Court, reported in AIR 1959 Supreme Court 443. Following propositions were laid down. Stated generally, a will has to be proved like any other document. The test to be applied being the usual test of the satisfaction of the prudent mind in such matters, as in the case of proof of other documents, so in the case of proof of wills, one cannot insist on proof with mathematical certainty.
This can be skipped, Mr. Ghosh.
My lord?
These clauses can be skipped. This is a judgment. From judgment, these clauses are removed.
Yes, yes.
So you can come to page 107 now.
107. No, 106, my lord. I shall come.
106, yes.
106. Number 4. Cases in which the execution of the will is surrounded by suspicious circumstances stand on a different footing. A shaky signature, a feeble mind, an unfair and unjust disposition of property, the propounder himself taking a leading part in the making of the will, under which he receives a substantial benefit, and such other circumstances raise suspicion about the execution of the will. That suspicion cannot be removed by the mere assertion. Oh, this is also, my lord, the
quotation from the judgment.
Yes, yes.
It ends at page 107,
Seven,
para 6.
Last paragraph.
Yes.
Section 63 of the Succession Act requires a will to be attested by at least 2 witnesses, and as per Section 68 of the Evidence Act, at least one of the attesting witnesses is to be called for the purpose of proving the execution of the deed. But in this case, no attesting witness is alive at the time of evidence, and the scribe even is not alive. But the executor Kalipada, who was present at the time of will, is examined in this case. It is held the Honorable Supreme Court, by the Honorable Supreme Court, in the aforesaid decision, that in the case of proof of will, one cannot insist on proof with mathematical certainty. From the earlier discussion of evidence on record, it is very much clear that the execution of the will by Mahadev is proved. The presumption of genuineness of the document as 30 years old registered document goes in favor of the execution and attestation. Now the learned advocate for the objector raised some suspicious circumstances surrounding the execution. Firstly, it is raised that the will bears the shaky signature of Mahadev Lal Sahu. He has also submitted that at the time of execution, Mahadev Lal Sahu was not bearing sound mind or sound physical health. I have carefully examined the signature of Mahadev Lal Sahu on the will, and these signatures do not appear to me to be shaky. No expert evidence is there to show or to prove that the signatures are shaky. So, my lord, the learned judge himself took up the examination, which is not proper at all. Secondly, it is argued that uneven distribution of property amongst the children and the wives itself brings suspicious circumstances. In this context, he has mentioned some terms of will. It is submitted that the properties were given absolutely only to Kartik Lal Sahu and in life interest to others. So only, my lord, the propounder was given the absolute title with the will. but not the others. Others are given as limited interest. Next page, my lord, 109. I have carefully gone through the will, and I have already mentioned in the first part of my judgment that the properties allotted to Santosh Lal and Rajlakshmi were not at all life interest in nature. Virtually, they are given absolute interest. In the context, learned advocate for the petitioner referred a decision of the Honorable Supreme Court in 2002, AIR 2002 Supreme Court 317, where it is held that uneven distribution of asset amongst the children by itself cannot be taken as suspicious circumstance. It is the sweet will or wisdom of the testator, the manner in which the property would be given, and the terms and conditions of the will. Nextly, it is the plea of the objectors that the will is obtained by fraud, misrepresentation, and coercion. The well-established principles of law held by the Honorable Supreme Court on different occasions that if a caveator alleges fraud, undue influence, coercion in regard to the execution of the will, such pleas have to be proved by him. But even in the absence of such pleas, the very circumstances surrounding execution of the will may raise a doubt as to whether the testator was action of his own free will, and then it is a part of the initial onus of the propounder to remove all reasonable doubts in the matter. Then the next page. In this case, the objector Saraswati is examined as OPW1. She has only deposed that the will is forged. As per her evidence, the will was obtained by fraud and coercion. She is unable to give any other evidence. She has examined one Samuel Mehta as OPW2. OPW2 has deposed that Mahadev Lal Chow did not use to sit at his shop after 1958 due to his illness. He claims to be mechanic having shop nearby shop of Mahadev Lal Chow, but in cross-examination it is revealed that he has obtained mechanic license in 1972 and he passed the diploma in 1972. If that we saw how he was working as a mechanic in the year 1958 is doubtful. I cannot rely his evidence. Objector fails to discharge the onus of proving for undue influence of coercion regarding execution of the will. Sila type kora to.
Yes.
From the instant will, it is revealed that Mahadev Lal Chow executed another will in the year 1957, and that will has been cancelled by the instant will, which are dealing with it. The learned advocate for the objectors has submitted that the earlier will contained even distribution of property, and by this date, there is uneven distribution of properties, which raises doubt. I have already discussed the proof of execution of the will. Testator has always right to cancel earlier will. He has also right to make second will in case of second thought. Execution of the second will in favor of other beneficiary of the earlier will is not invalid. It is contended by the objectors that Kartik Lal Chow, beneficiary of the will, actively participated in the execution and registration of the will. It is held by the Honorable Supreme Court in a decision reported in 2005 Supreme Court 4362 that active participation by executor in preparation and execution of the will is not itself suspicious circumstances. Further argument on behalf of the objector is that entire property as described in the will is not included in the application for probate, and as such the petition for probate fails. In this context, he refers to the decision of the Allahabad High Court reported in 1983 Allahabad, page 90. I have carefully gone through the decision, and it is revealed that the Honorable High Court did not dismiss the probate application for non-inclusion of entire property. The petition was returned for amendment so that the propounder may include the remaining property which were not included. In reply, the learned advocate of the petitioner refers a decision to Honorable Kerala High Court reported in 1994, Kerala, page 85, wherefrom it is revealed that there is no mandatory direction in section 276 and 278 of the Indian Succession Act that the petition for letters of administration should contain the entire assets scheduled in the will. The sections also do not provide any provision for dismissal of the application for the reasons that the entire asset shown in the will are not scheduled in the petition. Nextly, it is argued by the learned advocate for the objectors that the will was executed and registered on 15th of October 1960, but it is submitted for probate after long lapse of 26 years. This will be my second ground, my lord. A decision Honorable Allahabad High Court reported in AIR 2006, Allahabad page 86 is referred. Above argument on point of limitation is neutralized by counter argument advanced by the learned advocate for the petitioner, submitting that their lordships in the aforesaid decision were not pleased to consider the earlier decision of the same court reported in AIR 1983 Allahabad, page 386, where it is held that no limitation is prescribed for filing for grant of letters of administration. A decision of an Honorable High Court reported in AIR 1959 Calcutta, page 87, passed by the Honorable Division Bench is referred. In the said decision, it is also held that there is no limitation for application for probate. From the above discussion of evidence on record, it is amply proved that Mahadev Lal executed the last will on 15th of October 60 with sound disposing mind, with good physical health. He executed the will as per his own sweet will. On the other hand, the objectors failed to prove their allegation of forge and fabrication of the will. Practically, there is no evidence given on behalf of the opposite party petitioners to spell out the suspicious circumstances surrounding the execution as raised by the objectors. Petitioners are the substituted legal heirs of propounder Kartik Lal Saw. Petitioners are therefore entitled to get letters of administration of the will as paid for. So this is the whole judgment, my lord. Now, my lord, kindly I am placing the wheelটা কই গো wheelটা
Part 2. Part 2.
my lord, will is in the part 2 of the paper book. Second paper book, my lord, which was prepared, my lord, according to your lordship's direction earlier. Because the will which has been executed, my lord, is not very much legible. That's why, my lord, we got it. And there was a date was also wrong. So, my lord, this your lordship got it, my lord, the other thinner paper book.
Yes. What?
Likitong Sri Mahadev Lal.
Mr. Ghosh, why don't you give us a chronological list of the deeds which were executed? Give deeds.
Deeds.
Which has been referred to. The judge considered
Evidence.
on 15th October itself there was a gift deed. 15th October was the date of signing of the will. So if we can have that list, how many deeds were executed and when those were executed and to whom it was given, then it becomes easier for us.
But I said, get it done, my lord.
Yes, you proceed.
Yes. করেছিস
একটা করেছি আমি ওটা ছেঁড়া মানে নিজের মতো করে করেছি আমি এটা প্রেস করে
এর মতো করলে হবে না আমার মতো
আমি আপনাকে করে দেবো কি
Don't believe him.
I know, man.
He or me?
Both.
If he cannot believe me, then I'm nowhere.
And my insist is at the stake. No, we will. And thereafter he.
The position has changed. He was originally in my chamber. Now, my lord,
Subject to correction.
Gift deeds to whom given.
Those are my lord, that is exhibited document.
No.
Oh, that becomes chronological if it is given.
I have prepared a draft. So whether this will suffice, I can make it. I have tried my level to.
records and finding it out.
That's
I have prepared it in a manner.
a civil matter, document also all exhibited.
And the bottom my lord will find the deed to be in favor of whom it was executed at the date. I'll
উল্টা বলেছি
No, no.
exhibited documents চাইছেন জজ সাহেব
Exhibited the কবে কি
right, those are all exhibited documents. সিভিল কোডে কি এক্সিবিট ডকুমেন্ট হলে কি থাকে সেটা বুঝেছি পাশাপাশি এক্সিবিট নাম্বারটা লিখে দিতে
Some marking is there, my lord. Forgive me, my lord.
No, though.
My lord is asking for a list of dates marking the exhibited document which is exhibited.
No.
Much simpler than that.
My lord,
Much simpler than that. The documents, the gift deeds, when it was executed, in whose favor, and what was the.
yes,
That's
but
all.
it should be accompanied by exhibit number. All that has to be there.
বুঝা গেছে?
It will.
I'll make it.
আমার একটা কপি দিচ্ছে আমি দেখবো
না আমি এটা করেছি, এটা করে আপনাকে আমি দিয়ে দেবো।
আর মিস্টার ঘোষ, let's see.
library.
Yes, sir.
Lord, I'm for the petitioner. The father.
Argument kept on record.
No, we are not saying written argument on record because he has not concluded, na. It will be, you want to take it back? No, then we can do our homework. It will be easier for us. ওটা রেখে দিও সাথে। Yes,
My lord, the
your
father of
service is complete.
my lord, service is complete. But
Upon
there is a private respondent also, my lord, to submit.
private respondent is complete.
My lord.
Where is Rana Mukherjee? Dekhi dao. Yes, tell us what is it
My
about?
lord, the father of your petitioner, my lord, has disappeared, my lord, since my lord May 2025, my lord. My lord, we made a reasonable apprehension, my lord. We made a complaint to the concerned police station. FIR registered, my lord. There is the accused persons, my lord. Last seen with the accused person, my lord. The police has taken to the custody of the private respondent. Subsequently, my lord, released. My lord, since then, my lord, my father has not been traced out, my lord.
So
The
who
agent
is
about
that? Who is that private respondent? Habibullah.
Habibullah, my lord.
So Habibullah, he was the accused.
He was the accused, my lord.
Who was the FIR?
My lord, the page 25 is the FIR, my lord.
You are the son.
My lord, I am the son. And
Son.
my lord. And the complaint was made by my mother, my lord. There is a CCTV in front of the
just a moment. Very good. Habibullah was the accused.
Habibullah is the accused.
So where from? Why did you?
My lord, we have reasonable, my lord, knowledge, my lord, from the house in front of the house of the Habibullah, my lord.
Habibullah was arrested.
Habibullah was arrested, and my lord, 5 days was custody. My lord, subsequently he released bail, my lord.
When was he released?
My lord, that has.
So then charge sheet.
No charge sheet, my lord. 57 days is already over, my lord. My father is not traced out, my lord. There is a relationship, business relationship with the Habibullah and my father, my lord. Last seen, my lord, with the Habibullah, there is a, my lord, CCTV footage we already provide to the police station, Usti police station, before the officer in charge, my lord. Since then, my lord, my father is not, my lord, traced out.
Come on Wednesday because
Lord,
habeas corpus we take.
Lord,
এই দুটো রেখে ওই এভিডেন্স সার্ভিসটা দিয়ে দাও। Yes, next Wednesday.
My lord, I am for the petitioner. Advocate on record for the petitioner is ill. My lord, kindly.
Next
today.
Wednesday. Next Wednesday. Yes, 14.
For the petitioners, my lord, on the last occasion, my lord has
Yes,
died.
where is Joyan Banerjee?
I'm calling my lord. He is on the way, my lord. Just now.
Every day he is your colleague.
On the last occasion, my lord.
You have checked it up.
Yes, my lord. We have just got the reported judgment of the matter, my lord. If my lord kindly have a look.
No.
আমি আপনাকে citation টা করে দিচ্ছি।
Reported judgment of?
My lord has asked.
Oh, in the other writ petition.
Yes, my lord. Yes, my lord. This is the update we have.
What is the name of your client? Dinesh Kumar Goyal.
Yes, my lord.
Where is Miss Roy Choudhury?
Mrs. Roy Choudhury is engaged today. She just came and had to just leave because of
Then
some,
we hear it in her presence.
my lord, tomorrow?
It will be there in the list. If we reach, we take it up. Yes, not today. (16 and 17), it was mentioned before us. Chandrai Alam was appearing. She, wait, this is 15.
15.
Mr. Shah, you are in 16.
15.
15.
Oh, then
My lord, 15, my lord, concerns a challenge, my lord, to a tender. My lord, very interestingly, by a person who would otherwise not have any right to, my lord, participate in the tender. My lord, the background is interesting, and with the greatest respect, perhaps, my lord, the matter was not really, my lord, considered in the details which it should have been. My lord, I am, my lord, Daikin. I am a well-known, my lord, manufacturer of air conditioning, refrigerating, chillers, etc. Now, my lord, I manufacture chillers and compressors. My lord, these are, my lord, part of, my lord, total air conditioning systems. Now, my lord, this follows three kinds of technology. One is, my lord, monoscrew technology. One is twin screws technology, and one is tri-router screw technology. And my lord, this technology has been, my lord, made me world famous. I have presence internationally and in the country. And my lord, I regularly supply to all, my lord, participants in tenders for, my lord, total, my lord, environmental systems, including in metro railways, my lord, for air conditioning and other things. Now, my lord, in this matter, without taking your lordship to the papers first, what had happened is, my lord, the metro rail authorities had, my lord, floated a tender for, my lord, ultimately, my lord, air conditioning of the metro railway tunnels. And, my lord, naturally, my lord, the participants were persons who would, my lord, supply the entire system and not only chillers and compressors, which is, of course, an essential part of the system. Now, my lord, the tender was floated saying that, my lord, the chillers or compressors that are used may be, my lord, monoscrew, twin screw, or tri-router screw. Now, my lord, thereafter, my lord, there are pre-bid meetings that are held. I am invited to participate in these pre-bid meetings because, my lord, that is what I've been doing in all, my lord, systems across the country. I participate in the pre-bid meeting with, my lord, the tenderers who would otherwise, my lord, submit their bids. Now, my lord, no one raises any objection, no one raises any question, no one raises any doubt with regard to, my lord, use of monoscrew technology. All of a sudden, my lord, there is an alteration of the tender conditions, my lord, after the game has begun, which is, my lord, your lordships, my lord, have clearly considered this on many occasions, said you can't play the rules, change the rules of the game after the game has begun. And, my lord, monoscrew is taken out. Now, my lord, when monoscrew is taken out, my lord, naturally, my lord, my lord, not only suffer the consequence of this tender, because I will not be able to supply, my lord, chillers, compressors to participants who bid for this tender. But, my lord, I will not, my lord, be able to participate in any other tenders because they'll say monoscrew is taken out in this particular metro railway tender. So, if monoscrew is taken out, then you don't have a right to participate, and this will have repercussions across the country. And, my lord, my prejudice will be absolutely unparalleled. That is why, my lord, I came up before this court saying that, my lord, here, my lord, the tender conditions have been changed without reason, without justification, and there's an attempt to ex post facto justify it by saying that this is obsolete technology. Now, my lord, very interestingly, after I have, my lord, filed the writ petition, after I failed to obtain, my lord, the order because, my lord, the learned single judge felt that, my lord, this will not warrant any interference. My lord, now, my lord, they have floated a new tender. After, my lord, I am in appeal before your lordships, after I filed the appeal, where they've once again included monoscrew technology. Now, my lord, interestingly, my lord, the question is what would then be, my lord, the criteria for avoiding it? My lord, the reason is quite simple. My lord, so far as, my lord, of course, my lord, this is not something that we spell out, but, my lord, the underlying reason is, of course, to, my lord, ultimately favor, my lord, one particular category of tenderers. My lord, so far as monoscrew is concerned, I am the only, my lord, person who manufactures or uses the monoscrew technology. Tri-router, my lord, there is one participant. Twin screw, my lord, there are really three major participants, out of two of which, my lord, import their equipment from abroad. Only one manufactures in India. So, my lord, when we confine it to, my lord, twin screw, then effectively, my lord, we are confining it to one person. My lord, let us not go into that. My lord, the more important question is, my lord, today, when your lordships are examining this, your lordships are examining the decision-making process. I completely appreciate that, my lord, today, it is open for, my lord, a government agency or, my lord, the administration to decide as to what is the equipment that it wants to, my lord, install, what is the make of equipment, etc., etc. But, my lord, when you come out with a tender, and, my lord, this is not, my lord, the first time that monoscrew has been a part of these tenders, When you come out with such a tender and monoscrew is there, then, my lord, your lordship's scope of inquiry will be whether, my lord, this has been deleted, my lord, with proper justification or reason.
But what is the present status now?
My lord, the present status is, my lord, today, my lord, my lord, am excluded, my lord, from supplying chillers or compressors to anyone.
Orders.
No. My lord, the bid opening date, my lord, is not, bid opening has not happened yet. So, my lord, I have come with utmost promptitude.
On 7th, it has been opened, Your Lordship.
Well,
7th August?
that is the last date of submission of bids. It has not been opened.
Already opened.
Your Lordship, 7th of July, the bids were already taken and it is at the stage of verification with regard to the post experience, whatever experience they give. The department verifies from the foreign ministry whether those experience are correct or
7th is
not.
the last date for receiving bids. Bids not yet open, not yet considered, no work order placed. The tender process is still, my lord, at my lord, at an essence.
So you didn't get an opportunity
But
to participate?
I cannot party, my lord.
He did not participate. He is not a bidder.
I'll satisfy your lordship on the locus. My lord, now your lordships have expanded the scope of locus sufficiently to, my lord, include, my lord, participants who are not directly affected but indirectly suffered, my lord, major prejudice. That is, my lordship's, my lord, opinion on certiorari now.
But Mr. Shah, how can you come up with a prayer for interim order to stall the process?
No, my lord. My lord, what is my prayer? My lord, there is a, my lord, tender floated with certain conditions. The conditions are modified after the tender is floated. My lord, your lordships have, my lord, in not one but numerous judgments held that you can't change the rules of the game after the game has started.
You give us an authority. You are not a participant. You are a supplier to the participant.
Yes, my lord, that is, my lord, I'm prepared, my lord. That is a question of my locus.
Yes.
I am, my lord, ready to argue on the question of my locus. My lord, your lordships have now, my lord, I anticipated that this would be the first question that your lordships would, my lord, ask of me.
Yes, who is for you?
Your Lordship, Mr. Banerjee, Shwatarup Banerjee is appearing in this matter. Mr. Shwatarup Banerjee. Your Lordship, he is legs before another court. Your Lordship, before the single bench, we had filed a report as well, wherein placing on record that the mono screw and twin screw, there were only 2 criteria, not 3 criteria, out of which mono screw was given away.
Very good. We shall have to hear that.
Your Lordship.
So where is he?
His legs before another court. Your Lordship.
Ask him to be present, then we can, because you are proceeding with the contract.
Your
na?
Lordship.
We have to, good, bad, indifferent, we have to deal with it.
Your Lordship.
Wednesday, please don't prefer
Your
an
Lordship,
adjournment so that we can take up the matter.
Well, will it be possible to take it up tomorrow? Will your lordships have the time?
Tomorrow, Mr. Shah, we have a different.
No, I am not going to interfere with your lordships on that roster.
Tomorrow we have a fixed matter at 2 p.m. That primary matter.
Well, whenever your lordships find it convenient.
When is the next date? What is the present state? You have opened the. You have opened the bid.
Your Lordship, bid participants have been called in.
Right.
And their verification, it is stage of
Verification is in
process.
then when you are scheduled to take the final decision.
Your Lordship, the final decision would be taken on decision to probate.
Decision to TC minus.
Still, it is in process. It has not been.
It cannot be over by next week. So it is content. So hard, Mr. Shah. It is in no defect is there. Stamp reporters no defect is there. But Mr. Shah, learned senior advocate appearing for the
তাহলে তো হবে না, তাহলে
This matter.
যে original
উনি পার্সোনালি রিকোয়েস্ট করেছিলেন তো এরকম হ্যাঁ আমি আমাকে দেখে বলেছেন 28 এর কথা বলেছেন ম্যাডাম তো মান্নাকে
Yes,
they have
18
been
lakh.
requested by Mr. Chalmay Alam.
Yes, yes,
It fixed on 28. Sir, since Mr. Manna was all Mr. Manna.
Very good. We have kept it 2 weeks to on after 2 weeks it will appear.
Sir, can a date be fixed since the Lord the
আজকে date
sir,
কত?
the respondent is suffering? He said the aged person will not. So considering his age,
Our husband has expired, sir.
no, I am not praying for anything.
Then what you are praying,
I am
sir?
just praying, Lord, let a date be fixed so that Lord, the matter.
So that is a new prayer you are making, na? You come back on 31st and let us see. কবে 2 weeks? হ্যাঁ
31st.
কিছু না কিছু একটা বলতেই।
18 my lord, I am for the private response. The last occasion, your lordship was pleased to ask for a report.
Your lordship had asked for a report, my lord, whether any car is parked on the road. or not,
Sir,
my lord.
nano car in narrow road, that issue, my lord.
You are for the state.
I'm for the state.
Who is for the appellant?
I'm for the appellant, your lordship.
With a specially able child.
Your lordship.
But my lord, that child is now riding a
Your
cycle.
lordship, this is the medical report. As far as the child's health is concerned, your lordship.
Wait. রিপোর্টটা দিয়েছে কি? ওইটা হ্যাঁ ওটাই দেবে, ওটা ওর থেকে নিও না, ওটা ফেরত দিয়ে দাও।
Thank you. আমি দিয়েছি। কোনো গাড়ি যাচ্ছে।
We have asked you to file a report, not an instruction to the learned government leader.
Oh, I'm so sorry, my lord.
We cannot still
So
look
sorry.
into this.
So sorry.
No, he is so busy, this investigating officer. We have directed the respondent number 4.
Inquiry was done, my lord, as per
Whatever it
as
is,
per
sir, High Court has called for a report from him.
my lord, instead
This
of
is a
report, my lord, the heading
communication
is
to the
my
state
lord, the
admin.
heading, my lord, the heading is there, my lord. I can understand, my lord. The heading is not there, my lord.
He should be cautious. He should be cautious.
Appellant of what court?
Yeah. Okay. Respondents wouldn't touch your issue. They do not, even the cars not parked would the Yes, sir. You have given a written declaration that you will not park your car there.
Your Lordship, that was taken when I went to file the FIR against vandalization of my car.
How can we help you, sir? Nobody is keeping car on.
Your Lordship, they are. Your Lordship,
you
this
got
is the
the-
current status.
Have
Your
you
Lordship.
seen? No. We cannot look into photographs.
Your Lordship.
This report says that you have submitted. Nobody is keeping car there. অরুণ পাত্র, অশোক ভৌমিক, দীনেশ ভট্টাচার্য, পার্থ সারথী চক্রবর্তী, they do not park there. Who are the private respondents? You are
I am
those.
for the private.
They do not park their car there. Even the cars of both the appellants are not parked on the municipal road also. You have submitted a written declaration over this issue. Consider, where is the declaration? We, the undersigned resident of Block Sajama, that neither any one of us nor
This declaration has been given by the private respondents, my lord. This declaration has been given by the private
respondents, your Lordship.
But in your report,
No, my lord, my lord, it's in
the
continuation
report
of the, it is in continuation of the submissions of the private respondent, my lord. It should be read as, my lord, my lord, it should be read as the
They
private
did not
respondent.
give.
No, not it. It should be read as private respondent.
But they are not parking their cars there.
No, at present, nobody is parking their car.
Oh, it is those 4 persons.
Those 4 persons. They have given the declaration that neither any one of them or not the appellants.
They should have gone to you first. Why did they go and threaten this person? 2 ladies.
Lord,
My lord, we never threatened those ladies, my lord.
Then what made you give this declaration to the?
This declaration was given on the 16th, my lord. 16th of this month. After
16th of July.
July, my lord.
That is after
Passing of this order, when we went to inquire the matter, my lord.
I don't have the copy of the declaration, my lord.
We tried. We wanted to help you to ascertain from the police.
Your Lordship, twofold grievances are there. Your Lordship, why only 2 cars? Why only
See,
2
this
cars
is
has
not
been
a
submitted?
suit court, sir. Why he will not do it?
No.
Why I am parking?
Your
We are
Lordship,
not.
your
Try
Lordship,
to understand the scope of our intervention and then argue.
Your Lordship.
Police inaction matter. We have ensured that you will be protected.
Your Lordship.
But question is, we will pass an order that nobody will park
Your
any car
Lordship.
there.
Your Lordship.
Nobody.
Nobody.
Neither you nor any of the adjacent
Your
person. And if they keep, and if the police doesn't take step, we will haul up the police authorities.
Your Lordship.
What is your problem?
No problem, Lordship. My grievance was that only. In fact, my grievance was that only, your Lordship.
Tell your clients. After it is disposed of and you start parking your
We
car.
have our garage, my lord. We have all the 4 persons have their garage. And only one
Mr.
car.
Ahmed, you instruct your police authorities that
Nobody should park their car. Certainly, madam. I'll do that.
accordingly not to create petty disturbances. Yes.
Biplab.
Not today.
Lordship, in this matter, Lordship, in this matter, I'm appearing on behalf of the respondent, Your Lordship. On the last occasion,
yes,
Your Lordship, on the last occasion, Your Lordship, yes, in the matter, item number 19, Your Lordship, I'm appearing on behalf of the respondent, my Lord. Lordship, on the last occasion, had directed us to serve an affidavit in reply to the other side, my Lord, to the appellants. However, Your Lordship, Lordship,
Appeal is by the state.
Oh, appeal is by the state.
During pendency, one interlocutory application is preferred by the writ petitioner respondent.
In the appeal.
To that, during pendency of the appeal, an interlocutory application has been filed by the writ petitioner respondent. Then we file opposition to it. On the last occasion, kindly sees order dated 19.
Oh, he wants to file.
We filed our opposition, but they did not file their reply.
Yes,
yes, Lordship. Yes, Your Lordship. For that matter, Your Lordship, I have an innocuous prayer to make, Your Lordship. For the last 3 weeks, Your Lordship, I have not been able to contact my client at all. Neither he is responsive on the call, neither on WhatsApp, neither anywhere, Lordship. For which I have not been able to affirm the affidavit in reply. Your Lordship, Lordship keeps it next month on the monthly list, Your Lordship. Why I will say because Your Lordship.
Listen.
Because Your Lord. Yes, yes, sir.
We are keeping it next Thursday. If you are not able to contact your client, we will proceed on the basis of the documents which are recorded. Matter cannot indefinitely stand. They are the appellants. Next.
Definitely, Lordship. Lordship gives me extended by a week, Your Lordship, more than.
So we are on Thursday. We are giving you on Thursday.
No, Lordship kindly gives me 2 weeks because for the last 3 weeks I have not been able to contact. I'll have to physically send someone to his residence for instructions.
Gali blunted. Hard Mr. Gali, senior government advocate appearing for the appellants. Mr. Kabir.
Abhishek Kabir, yes, Lordship.
Appearing for the respondent numbers.
The main respondent, Your Lordship, Shukanto Construction.
Appearing for how many? Appearing for the
writ petitioner applicant.
Writ petitioners.
Writ petitioner.
Yes, Your Lordship. Yes, Your Lordship.
Writ petitioners.
Applicant. Is the applicant.
Respondents. Praise for extension of time. File the affidavit in reply.
Yes. Yes, Your Lord.
As a last chance, the time to file such affidavit in reply is extended till 30th July.
Grateful, Your Lord. Yes.
The matter for further consideration under the same heading on 31st July. Yes, next. 31st Corona. On 5th August. On 5th August. Yes, next. 20.
The IAPA for the petitioners.
My Lord, Mr. Orijit Chakraborty is appearing virtually, my Lord.
Ask him to appear. Virtually, we won't be able to post.
My Lord, I am appearing. I beg to appear on behalf of the Respondent Enforcement Directorate online, my Lord. I am suffering from cough and cold, my Lord, so I prefer not to come to the court, my Lord.
Get well and come back.
Very well, my Lord. Very well, my Lord. Kindly keep it next week, my Lord.
Next Thursday.
Next Thursday. Very well, my Lord. Item 20 and 21.
2021.
Very well. Deeply obliged.
Seems to be changed whenever Mr. Chakraborty is there. We are not here.
He is, my Lord, on the.
Is not available.
Yes. But you must notice the special interest that I am taking in this matter. Please
come next Thursday.
Very good. Deeply obliged.
কটায় বেঞ্চ আছে আমার
Both the matters, 20 and 21.
Yes. Action দাঁড়াও। Next matter 22.
But I beg to appeal on behalf of the appellant.
Where are you?
চেম্বারে বসে আছে।
No, my lord, I'm not there in Kolkata today, my lord. I'm sorry, my lord, I'm not there in Kolkata today.
Next Thursday.
Let's say appear for the private respondent. But there was a direction upon even us to file our affidavit in opposition. But somewhat, we could not file. But I'm seek a 1 week's extension, to file my affidavit in opposition.
This has been ages, my lord, since they, my lord, they have not filed this opposition.
Out of Jharkhand, so there was some.
We cannot indefinitely give the time.
1 week, my lords, 1 week.
24th, yes.
So grateful, my lords.
Grateful.
This was the affidavit in opposition that you've asked me to file. Both the copies are over there.
The affidavit on reply, Your Lordship, I have served the respondent via email. I will just serve him a hard copy.
Tell us what is the matter.
Lordship, no, Your Lordship, before that, do we need to file paper books with regard, because Your Lordship on the last occasion was pleased to.
Has the appeal been admitted? Has the appeal been admitted?
Yes, Your Lordship, the appeal was admitted.
So in the writ petition, was there exchange of affidavits?
No.
Now the pleadings are recorded.
Yes.
He has used his opposition.
Yes. Every pleading.
My lord, in that writ petition, when I asked remanded, when whatever submission was made, that was accepted before the London court, they did not file any, they did not make any kind of objection. In fact, they said that we are ready to give them what kind of information they are asking for. And they did not had any objection with the contents of the RTI matter.
Wait. What information did you want?
Lordship,
Sir, you are our officer first.
We
will expect that you will settle the problem. Please tell us.
There were 8 questions asked by the writ petitioner. 8 questions or 8 informations.
8 information.
Yes. Out of that, Your Lordship, now this information pertains to an examination of 2000 and 1998, asked in 2024. The writ petitioner purportedly appeared for that exam. In 2024, after a delay of 24 years, he asked certain questions.
I got objection. That is not.
Sir, wait. This is not the procedure. We will hear you.
Oh.
Without hearing you, no order will be passed. Please take your seat.
Yes, sir.
So, Your Lordship, after 24 years, the information was sought for. Then
he was a participant in the
examination.
What was the examination for?
The examination was for selection in the post of in police by a board which has been dissolved afterwards also.
Very good.
Yes. For the post of if I'm not
very good. Then it was an examination for recruitment.
Yes, for recruitment. Then he asked certain questions.
Very good.
Then it was disposed of. The writ petition, he filed a contempt. In the writ petition, while it was disposed of, the averment that or rather the submission that the state made, that the information, whatever was available, was made over to the writ petitioner. However, the writ petitioner filed a contempt. In the contempt proceedings, the objection or the opposition to the contempt was filed. In the meantime, we filed an appeal. The appeal was admitted and question of law was framed by the Honorable Chief Justice, division bench presided by the Honorable Chief Justice, stating on the prima facie that few of the questions, in fact, E, F, G, H, questions as asked by the writ petitioner, whether they are tenable under the law as information in the Right to Information Act. This was a question of law framed. And thereafter, the appeal was heard by this Honorable Division Bench. And on that score, we got a stay over that judgment. Because the information he sought for was probably not an information under Right to Information Act.
Show us the information he sought for. Mr. No, we were asking whether is it any possibility of settlement, that any sort of answer.
Information sought is Malad of.
No, on the merits we will go. As you are there, we are asking.
No, Malad, not one of those matters. Not one of those matters, Malad, for the simple reason that Malad, the
absolutely speculative information. It is not information. The queries are absolutely speculative. So there's no reconciliation, my lord.
Maybe speculative to you, but not to the authorities. Then they would have said that is a speculation on the basis of
So kindly
speculation.
read the, my lord, then kindly sees what information has been sought.
Yes,
Page 17.
take us to that.
Page 17. Page 17. Well, kindly take page 17. Or the stay application.
Seventeen.
17. My lord. First, kindly takes, well, the opening paragraph, sir. I was a candidate for the.
No. This page
16 July 2022.
You are showing
Can
page
one.
can one? No, section 5 আছে.
Yes, section 5, my lord, there was a delay of 275 days. It's allowed হয়ে গেছে তো।
That was
That
disposed.
has been allowed.
That has been. কি আছে ওর? Where you are reading from the
Stay
stay
application,
application?
page 17.
Can two.
Can.
Yes, third I was the candidate for the.
Now kindly take the date. Date means date in the paragraph. I was a candidate of the preliminary exam in the year 2009. So information is being sought in 2022.
That we have been apprised. Yes, next.
Now kindly take the nature of it. I want a copy of the answer sheet of the preliminary examination given by me. Copy of the answer sheet of the final examination given by me in respect of every subject, and I also pray for the marks given to me for personality test also with reasonable grounds for it. Then B, sir, I pray for a copy of the selected candidates in regard to preliminary and final examination of every subject, also regarding the marks given to them in personality test along with reasonable grounds for it. Then, sir, I pray for information that whether the competent authority did take any bribe money for selecting the selected candidates for the post for the said above. So kindly give me information about the detailed inquiry by the department itself. Then D, sir, I pray for information and that whether competent authority did take any bribe money for selecting the selected candidate for the post of the said above. So kindly give me information after detailed inquiry by the Directorate of Anti-Corruption Bureau and of Government of West Bengal. I want information whether the competent authority did take any bribe money for selecting the selected candidates for the post in regard to the said above. So kindly give me information after a detailed investigation by CBI, so and so. So not my domain. Kindly give me information in regard to re-examination said above, that what would have been my rank if there had been no corruption in regard to selection of candidates only if any matter of corruption of the said so and so. So the entire thing is speculative. What should have been, what would have been. আটে একটা আছে তো?
Very good. Then
my lord, same thing is repeated in the appeal
what
also.
did you do? Replied anything? You didn't reply.
So my lord,
did you give any reply?
No, my lord, no reply.
No reply. So he came to High Court.
He came to High Court, my lord.
So what is page 31, sir? What are these documents you have annexed?
No, these were part of the writ petition. These were annexures to the writ petition.
These are annexures to the writ petition. Where is the writ petition? Do you have the writ petition with you? We have it. That he has annexed.
Supplementary?
No.
Fine.
Supplementary evidence. So now take us to, so this after this nothing happened.
No.
Then
thereafter, my lord, there was a direction of the Honorable Court, and thereafter, my lord, your lordships will kindly find page 26
of your stay application.
Of my stay application.
Yes. What is that?
My lord, pursuant to direction of the Honorable Court.
Pursuant to direction of his lordship. This is as per direction of such and such. Copies of the
earlier correspondences were given to him. Those which were available.
And then, my lord, your lordship will kindly take page 28, where we have said that since it is an old recruitment process and there is no document available to us. Page 28. My lord has taken
You
page
said
20.
answered for all the questions except question number 8. So question number 8 you replied.
Question number 8, the office maintains the vacancy position periodically. That answer is there in this document itself. Next paragraph.
Oh, I see.
We have said that the question is vague, so we cannot give the information.
Now take us to the impugned order.
Hello, that will be at page 14 of the stay application.
Yes, place it.
Having taken up, kindly.
Yes, having not.
May I place it on second page?
Yes, yes.
It is submitted that the said appeals are not maintainable in view of the information having already been given. In the present case, the peculiar circumstances is that the respondent authority does not express any reservation to furnish the information as sought by the petitioner. The only grievance of the authority is that such information has already been given. Be that as it may, since the petitioner is of the opinion that the petitioner has got the information sought, the matter can be mitigated by directing the respondent to furnish the information in its entirety as sought by the petitioner. Such course of action shall render the first appeal and the second appeal of the petitioner infructuous, thereby relieving both the parties of unnecessary pending litigation. Accordingly, so and so is disposed of, directing the respondent to furnish the information in terms of the query of the petitioner at the earliest positively within a week from date. The appeal pending at the base of the petition and disposal will make clear the party shall act on server. So, my lord, the test whether it was falling within the bracket of information under the RTI Act has not been undertaken by the Honorable Single Judge. So, my lord, for that.
RTI Act দাও
আমাদের কাছে অন্য কথা বলছি জাজমেন্টের কপিটা বলছি ইনফরমেশন দিয়ে দিয়েছে
one is central not express any reservation to
response of the authority is that such information has already been given.
Now, Mr. Bandyopadhyay, come back to the order.
The rejection order, madam.
No. The Justice
The impugned
Bhattacharya.
order. Come to page 2 of that order.
Page 2.
See the second paragraph.
But this information is not there with us.
No, you're saying it's already been given.
That is what is being referred to is the document I read. The document I read, my lord, that I have no information with regard to 1 to 7, and as far as 8 is concerned, we have given in there, then and there. পুরো দেখো নেই তো হ্যাঁ 27 মাস তো এটাই তো this recruitment I must point out before placing the act, this recruitment was done by the Kolkata Police Recruitment Board in 2009. In the meantime, this board has also been dissolved by an order of 27th of May 2021. And that one I have annexed at page 29.
এইটা একটা মিনিটস হয়েছিল ভারতে যেইগুলোতে পেন্ডিং ছিল কেসেস সেইগুলো রাখা হয়েছে বাকি সব
না একটা ছিল না কদিন পরে রেজিস্টার করে দেবে
এই তো 12
এটা কিসে আছে সাপ্লিমেন্ট
না আমাদের রিপ্লাই আমি রিপ্লাই দিই
জায়গাটা দেখানো তাহলে
এই ওয়েটিং
No, now what point of law has been this is 15 January order.
Yes,
It's 16.
Well, that is a prima facie view, but I'll satisfy from the, I did not get the occasion to place the Supreme Court decision in entirety.
No, there is no stay, no? There is a stay.
The stay as far as the contempt is concerned.
No, there is no stay.
So
You have been asked to make a request to the learned senior judge.
Well, we have
Mr.
made the request
Dinda
and it
had-
has been adjourned simultaneously.
Mr. Dinda had said the earlier division bench had framed certain points of law.
Yes, that is, your lordships will kindly take the order of 15 January 2025.
15 January.
Yes.
But will first take, I'll take your lordship back to the preceding paragraphs. Kindly take the issue framed at paragraph 8. Thus we are of the view. Thus we are of the view that the legal issues are to be considered apart from
That's paragraph 8. The learned government figure. কতটা
I'm sorry.
নিশ্চয় দেখছো?
No, legal issue in the preceding paragraph. I'm sorry. 6. I'm sorry. Paragraph
15
15 January 2025.
already হয়নি। একটা there is 20th Jan. Yes, what you're saying?
But kindly take some paragraph 5. In our order dated 26 June 2024, we had recorded a prima facie view that the information sought for in prayers C, D, E, F are not in the nature of a query seeking for information, since the respondent petitioner seeks for detailed inquiry to be conducted by the Directorate of Anti-Corruption Bureau under the Government of West Bengal / CBI. Therefore, the legal question which is required to be decided in this case is whether the prayer sought for in the above clauses would qualify as information to the query under the provisions of the Right to Information Act. With regard to the other two queries, the information sought
Other
for,
two query means which one?
This is C, D, E, F, A and B. A and B is the other two queries. With regard to the other two queries, the information sought for is that after a period of more than 12 years after the examination was taken by the writ petitioner, the applicant would contend that the records which are required to be retained or preserved is in terms of the Kolkata Police Recruitment Board, and only when the litigations are pending, the records are kept, or else there is a destruction policy by which time frame is being fixed so as to which of the records has to be preserved and which could be destroyed. This we have also given in the reply. This resolution by which we follow the SOP kind, that which we follow for destruction of records, we have given in the reply. The reply page, it is at page 11. Your lordship may take page 12.
Come on Monday, we have another bench now. Oh no, Monday to হবে না। Keep it on Wednesday.
মিটিং এ যাচ্ছি।
বুধবার তাহলে বৃহস্পতিবার রাখো। We keep it on Thursday.
Next Thursday, coming Thursday.
You have any problem?
Coming Thursday, I don't have a problem.
Or we can keep it the Thursday week, because all the pleadings are on record. No use of filing any paper book. We will finally decide the matter.
Thursday, kind. Well, the matter may be over, short point.
Very good. Thursday.
Yeah, my
Coming Thursday.
learned friend has no difficulty.
Okay.
Now, coming Thursday is কবে তো? 24th রেখে দাও। অনেকগুলো আছে। 24th Monday. হ্যাঁ 28 তারিখ বললে না? 28th is Tuesday তো।
28th is Monday.
ঠিক আছে। Hard Mr. বন্দ্যোপাধ্যায় learned
And he said he made a wrong statement.
My lord,
So far,
my lord,
We will delete that.
that paragraph will
my
delete.
lord, kindly keeps it on next Tuesday or Wednesday, my lord.
No,
Kindly.
no,
my
we
lord.
have kept it when?
On
August first week?
August, my lord.
Yes.
Or
Let them
kindly-
conduct the.
My lord, the FIR is dated 10th of May, 2025, my lord.
Pardon?
My lord, the FIR.
Huh?
The FIR is dated 12th of May, 2025, my lord. My daughter is missing since 10th of May, 2025, my lord. My lord, nothing has been done. Kindly keeps it next week, my lord.
Madam, it will, because if on that date they have,
I shall inform. I shall.
on that day they are conducting a date, give them one more week time. You are concerned with the missing of
My lord, my lord,
of your daughter, so we are in scene of the matter.
my lord. My
Let it come on that date, we shall.
Lord, may I mention one matter? Item 27, my lord.
কে রেখেছে? Oh, we have kept it on 23rd July. তাহলে বলো বলবো। Yes, we have kept it on 23rd July. We kept it on 23rd July. My office.
23rd of July, my lord.
My lord, item 27, my lord, could it be
How
taken
you-
up next Thursday? Because I won't be in town.
So take us along with you. What can we?
But item number 25 as well, my lord.
Lordship
Will
will,
not be out of time then.
My lord, I will have to
Lordship keeps it on
Bombay with my son.
next Thursday, my lord.
Huh?
Item 27, next Thursday, I'll
Other side.
my lord, the state,
My lord, item number 25, my lord, other side is here.
আরে স্যার ওয়েট,
Sorry, sorry.
একজন বলছে তো লাফালাফি গেল না, একটু বয়স হলো তাহলে। 27.
yes, my lord.
Your other side will come and embarrass us.
I'll inform him. Just now I'll inform him. I'm grateful.
Which is
25, my lord, Thursday week.
who is your other side?
I'm for the appellant.
So let it go out of list. You mention
No,
you're going outside, na? You
No,
visit
my
that place and come.
will be outside.
My lord, I will be going.
Problem.
So visit that place and come.
My lord, only for 4 days, my lord. Only for 4 days.
25 টাকে করে দাও কবে?
Thursday week.
Thursday week.
Grateful, my.
No.
ইয়ে করেছে চশমাটা ফেলে এসেছে। Sir, you go before another. একটু লিখে নাও কি আছো এই কবে অ্যাসাইন করেছিল এটা তুমি দেখালে
From 2015. 2000.
the matter was assigned before this সাইটটা দাও Here. Who is there? You're there.
I'm for the plaintiff, my lord.
In this matter, was there any application for addition which was considered?
Addition, yes. my lord.
Yes.
That I considered, no?
Yes, your lordship had considered that, my lord. Your lordship had also, my lord, passed an order to that effect also, my lord, and I have to,
Again.
my lord, really, my lord, check the orders, my lord. It's been quite some time, quite some time.
Yes, it was quite some time. আসো এটা কবে অ্যাসাইন করেছিল
But there is also one more thing, my lord. My lord, there is, my lord, arbitration, my lord, petition, my lord, which was also, my lord, assigned before your lordship, my lord. AP, my lord, 661 of 2009, which is not
that you
appearing.
did not mention?
Perhaps, my lord, it was not given in the list, my lord. It was my, my lord, fault. That was.
I am releasing the matter along with all connected applications.
Would it be your lordship's pleasure to, my lord, also, my lord, treat this, my lord, AP number 661 of 2009 in the days list and, my lord,
It's a much earlier application. Na?
It is.
Had it been a recent one, I could have done it. But doesn't matter. On the basis of the assignment you will be setting, you will add this number.
This, my lord, all the applications are there in the suit. I am for the plaintiff, my lord. I believe my learned friend is for one of the defendants.
And what is the application?
This is, my lord, arbitration petition, another petition, my lord. Arbitration petition of, my lord,
So that has nothing to do with this, or it has connection.
It is, my
So
lord.
what
It is
is
a
the
section.
application
It
number?
is a section, my lord, 34. If I am not wrong, my lord, it's a section 34. So they can have.
দিতে পারবে কি? Treating it as on ফাইলটা when it was assigned to me,
Yes, my lord.
the applications which came, which included your AP 661 of 2000.
Oh, very well.
So when I am releasing the matter and saying along with all connected applications, that would automatically come in this.
My lord, that will be, my lord.
Today, if I see today, if we say that I am treating it as on days list, and then there will be some problem.
As your lordship pleases. If
Any problem, come back.
Yes, absolutely.
Like এটা তুমি this matter was
because my lord, AP was not filed in suit. It was a separate proceeding under section 30 was challenging a family award. But I'll, my lord, let me ascertain, my lord, if your lordship, my lord, this order, my lord, is there, my lord, then I'm grateful to your lordship.
Or any problem you mentioned.
I'll definitely, my lord, I'll definitely. I'm grateful.